last item, my lord. Actually,
Yes.
this is a part her matter, my lord. I have already completed my argument. My learned friend is to argue, my lord.
Yes.
We have no choice of the court, but order is
Yes.
there, my lord.
Yes. Yes. Yes.
It
Okay,
is a
no
part
problem.
matter
Okay.
before Justice Srikia, your lordship.
Heard, Mr.
ठीक है, कोई चला.
P.K. Kolita, learned counsel for the appellant, and Mr. Biswas,
A Biswas.
learned counsel for the respondent. It is submitted at the bar. This matter is a part-heard matter of another court in advance of this court. Accordingly, it is provided that Justice shall list the matter before the appropriate court.
Obliged.
Your lordship.
Lordship, in item number 5, that has been shown, item number 8, that has been shown to be connected with RFA 51 of 2015. That is not connected, Lordship. It can be detected.
My lord, the item numbers 8 and 9, the 9 ought to have been RFA number 51 of 2016, my lord.
Acha.
Wrongly RFA number.
Yes. What to do?
So, Lordship, RFA 51.
Both the matter are to be tagged.
Lordship, RFA 51 of 2015 is to be detected from this RFA 53 of 15.
Okay.
And RFA 51 of 2016 is to be tagged in the matter, my lord.
Okay. Okay. Heard, Mr.
M does
M. Does learned counsel for the
for the respondent.
appellant respondent number
Respond all the for 1 to 3.
for
Item number 9,
respondents
In item number 9,
for respondents
1 to 3.
in RFA number 51 of 2015. The learned counsel submits that this RFA 51 of 2015 is wrongly tagged with RFA number 53 of 2015, and therefore it is contended to segregate item number 8, RFA number 51 of 2015 from item number 8, RFA number 53 of 2015. Justice shall do the needful in this
Sure.
regard.
Lordship, one prayer, Lordship, in respect of item number 5, Lordship.
Okay, 1
My
minute.
lord, in item number.
So, yes, this 51 of 2016 has to be tagged with
Item
this.
number 8, my lord.
8.
53 of 2015.
I am appearing in item number 8 as the appellant's counsel, your lordship.
Heard, Mr.
A Biswas, your lordship.
N. Chaudhary for the respondent in item 8.
Respondent for the respondent number
All the respondents, my lord.
for the
1 to
respondent
8 is.
and Mr. Biswas for the
The
appellant.
appellant's, your lordship.
It is submitted at the bar that RFA number 53 of 2015 has to be tagged with RFA number 51 of 2016. And accordingly, it is contended that both the matter may be tagged together and list accordingly. Pair is accordingly allowed. Rest shall do the needful in this regard.
Deeply
Obliged.
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 Lordship, in respect of item number 5, we have taken the consent of the petitioner side, Lordship. In this case, I am appearing on behalf of Mr. K. Agarwal, Senior Counsel. We had to leave for auto station, Lordship, yesterday night. Lordship, can it be taken up after 3 weeks?
Mr.
Mr. M does, on behalf of
Learned Counsel appearing on behalf of Mr. K. Agarwal.
Yeah.
Learned Counsel for the
will be applicant, Lordship.
Learned Counsel for the applicant in MC 661 of 2012. You inform the other side
Yes, Lord.
with
I informed
consent
Mr.
from the
P.
other side. Price for listing the matter after
3 weeks.
23.
After 3 weeks, Lordship.
After 23.
Yes.
So item number 5 will be same order.
Lordship, item number 5 is the
Okay.
same one.
Okay. Okay.
Obliged, Lordship.
Yes.
Wait, please, Your Lordship, I beg to mention listing of an IA. It's
When?
orders.
When?
Your Lordship, it is a RSA matter of 2013.
When do you want?
Any date, Your Lordship? The next week, if
Take a
possible.
date from him.
On 19. On 19.
Yeah, please, lordship. Lordship, I did mention unlisted matter today for withdrawal of a transfer petition, lordship. On withdrawal-
Today?
Today, lordship.
Possible?
For withdrawal.
Okay. Okay.
May I please, Lordship? Lordship, my pair is for listing at contempt case, Lordship.
When?
Any date next week.
On 21st.
21st.
May please, Lordship, I want to mention regarding listing of two matters on Monday. One is RSA and one is MFA.
Possible?
One on Monday, one on Wednesday.
Tuesday,
No, one on 12, one on 14.
Happy. This is for urgent listing of a matter tomorrow, Lordship, for civil revision petition because the
Criminal?
civil revision petition.
Ah.
Because the Nazir has fixed the date tomorrow for execution, so matter may be taken up for motion tomorrow, your Lordship.
Possible tomorrow?
First, Lordship.
Okay, we'll try.
Oblige.
Yeah, please, your lordship. I beg to mention for listing on testamentary appeal, can it be on Monday, lordship?
Monday. We'll try.
Lordship, listing for orders matter, Lordship, testamentary appeal, Lordship.
Pardon?
Testamentary appeal, Lordship. I'm praying for Lordship, listing for orders column, Lordship.
On 16th.
Monday.
16th August.
Okay.
Deeply.
Okay.
Lordship, I beg to mention two orders for order,
When?
any date.
On 19th.
Much obliged.
Lordship, item number 4, Lordship, may kindly fix it, Lordship, can it be fixed on Tuesday next, Lordship? One written argument is to be given, Lordship, but I could not place of the file in the house.
Tuesday.
Tuesday,
Next Tuesday.
Right.
Yes, Gogoi?
I have prepared as per your direction, I have prepared a bunch of Thursday and all this. I'm to submit it.
Yes, you can submit to the court master. Mr. P.S. Lokor, learned counsel, learned additional PP with consent from the other side, press for listing this matter on Tuesday, next Tuesday.
On 13th.
Fair allowed.
I mention it so that he can feel, Lordship. I mention it so that he can, petitioner counsel may be feel, Lordship, that is, I am here, Lordship.
Okay.
Matter number 1, matter for orders.
Main piece of order. This is a petition for condonation of delay, Lordship.
Or
Condonation of delay of 131 days, Lordship. My learned friend has not filed any objection to the petition.
We do, your lordship, we do not have any objection. Later delay may be continued.
you have no objection. You are for
Respondent 1,
respondent 1.
later delay be continued at the same time. Delay will be continued.
Yes, madam, you are for
For respondent number 2, 3 and 4, my lord, Soil Conservation Department.
2, 3, 4.
Yes.
So you have also no objection.
Your lordship, registry may be directed to this the appeal within a week.
Pardon?
The registry may be directed to this the appeal within a week.
Hmm.
A week time may be granted.
Heard Mr. R. Sharma, learned counsel for the applicant. And Mr.
S.A. Bakhtiar.
S.A. Bakhtiar, learned counsel for the respondent number 1. And Mrs. R.S. Devi, learned standing counsel for the respondent number 2, 3, and 4. This application under section 5 of the Limitation Act is preferred by the applicant.
One 31 days, Lordship.
MSNK MS NK Production, a preparatory concern for condemnation of delay of 131 days in preferring connected appeal against the judgment and decree dated 1/9/2022 passed by the learned civil judge number 1 Kamrup M in TS number 231 of 2019. It is to be notated by the impugn judgment and order dated 1/9/2022. The learned civil judge number 1 Kamrup M has decreed TS number 231 of 2019 in favor of the plaintiff. Mr. Sharma, learned counsel for the applicant, submits that in which paragraph of your petition you have mentioned the grounds?
There are 3, 4. 3 and 4.
Paragraph number
3 and 4.
3 and 4. So what is the ground?
Actually, what happened, we did not have the knowledge of the judgment because in the meantime, COVID-19 was started and during the pendency of the that time the judgment was passed. After the COVID was over, but here the advocate lost the track at that time. And therefore, when they received the notice of execution case, then only they came to know that the judgment was delivered. There was some formality was there. After observing that the appeal was filed.
The learned counsel for the applicant submits that the applicant was not aware of about disposal of the case, and at the relevant time there was COVID-19 pandemic also prevalent, and that the delay of 131 days in deferring the appeal is not intentional, rather it is circumstantial, and the same has been sufficiently explained in paragraph number 3 and 4 of the petition. And therefore, Mr. Sharma has contended to condemn the delay of 131 days in preferring the connected appeal. Or contra, Mr. Bakhtiar, learned counsel for the respondent number 1, and Ms. R.S. Devri, learned counsel for the standing counsel for the respondent number 2, 3, and 4, submits that they have no objection in the event of condemnation of 131 days delay in filing the connected appeal. Further, having heard the submission of learned advocates of both the parties, I have carefully gone through the statement and affirmation made in the paragraph number 3 and 4 of the petition of the application, and it appears that the applicant had sufficiently explained the reason of delay, the paragraph number 3 and 4 of the petition. Further, having taken note of the same and also taking note of the facts and circumstances on the record, as well as submission of the learned advocates of both the parties, this court is inclined to condemn the delay of 131 days in filing the connected appeal. In terms of above this, highest density disposal. Now the registry will proceed to register the appeal,
Lordship,
and
my humble prayer is a week time be granted to release that.
Some date may be
registry
fixed for
cannot be
some-
granted week time. They will immediately list the matter before the court.
And number 2,
All right.
May I please allow it? Okay, in this case, due to the miscommunication between the officers of the department,
a delay of 357 days had occurred, Your Lordship. And Your Lordship, on the last occasion, this honorable court had directed us to, on 16/7, to take justice service. And we have taken justice service, and the service was completed upon the full respondent on 25/7/24, Your Lordship. And we had filed an additional affidavit to bring that same on record. It is there, Your Lordship, with regard to that. I think it has been tagged as the pink flag mark of there. And the service upon Pradeep Kumar Das has been shown to have been completed, Your Lordship. On 25/7/24, he has endorsed the same in page 26 at the bottom. His signature is there, Your Lordship, in the affidavit we have filed. But none has appeared today, Your Lordship, in spite of the service of the notice.
So let us take it up on Monday. In the meantime, Resti will put up an up-to-date office note in respect of filing of any Ukalatnama by any counsel for the opposite party or respondent.
But that copy had been served on 25/7.
25/7.
Yes.
Let us wait till Monday.
And the next day is on 13th of this month, Your Lordship.
Next date is
13th of this month. That is on Tuesday next, Your Lordship.
where the case is pending.
One Lordship. Kamrup. Senior Division number 1, Kamrup, Your Lordship.
Monday will be then.
Monday on 12th, it may be taken up, Your Lordship.
Yes.
And the delay part and the stay application is also there, Your Lordship. Because if Your Lordship condones the delay, then only the
Record will be put up before this court, will be listed.
because the execution proceeding is has been initiated. We came to know only on the process server visited the site, because there is a total miscommunication between the officers, because I have annexed the documents to substantiate that, Your Lordship, because the executive engineer had directed the government pleader to take the necessary steps with filing the appeal. However, till date, it appears that it was not filed. When the process server went to serve the copy for attachment of some of the properties of the department, then only we became aware, and that process was initiated to file this instant appeal, Your Lordship. And during this miscommunication between the officers, and Your Lordship, be aware that the officers keeps changing. So that is the part of a department we are handicapped in that manner. And we were not represented by a legal, it was only represented before the trial court by the government pleaders, who did not properly interact, because here, as in the High Court, there are some designated standing counsels, which is not there in the trial court, Your Lordship.
Who is responsible for the same?
Lordship,
Mhm.
I have placed the facts before Your Lordship.
So you also have to explain the same in the same manner, like ordinary litigant.
It is there, Your Lordship, but
Then
some laxity with regard to there are judgments. I understand the point, but the thing is, Your Lordship.
So let us take it up on Monday. Heard Mr. Biswas, learned counsel for the applicant. Mr. Biswas submits that as per direction of this court dated 16/7/2024, the applicant has effected service of notice upon the respondent on 25/7/2024 and filed an affidavit before this court on 1st of August 2024. But till date, the Respondent respondent opposite party remain unrepresented today. Recessal list the matter on Monday and put up an up-to-date office note regarding filing of any ukalatnama by any council for the respondent number 2 or for the respondent.
For hearing item number 3, forward matter.
Lordship, this is NDPS Lordship.
Hmm.
At present petitioner is in bail Lordship. He was for
He is
2
in jail.
At present he is bail. He was under
Bail. Bail.
yes.
Huh.
He was in jail for 2 years, 5 months. Then a bail application was moved and by fight order dated 26/2/2021, bail honorable court allowed granted him bail, and from thereafter from February 2021 he is at present he is in bail.
So what is the term of imprisonment?
His imprisonment is 7 years.
7
He
years.
is with fine Lordship, with default clause is also there.
7 years. So what was the contraband substance?
This is ganja Lordship.
What is the quantity?
Quantity 4.8 kilogram.
Only.
Yes. Suspected ganja. In fact, it's a plant. The leaves are most are leaves.
So what is the punishment prescribed for the same? Section 20
Section
A
20, conviction under section 20B.
B.
Yes, Lordship.
That is intermediate quantity. 20B.
20 AB of NDPS conviction under section 20B.
So what is the punishment prescribed under section 20B? Mr. Loskar, you are ready?
Going to Lordship.
Huh?
I'm going to Lordship. Yes.
20B, Lordship, produces, manufacture, possesses, sell, purchase, transport, import, interstate, export, etc., where such contravention relates to clause A with RI for a term which may extend to 10 years and shall also be liable to fine, which may extend to 1 lakh rupees. And where such contravention relates to subclause B and involves small quantity with RI for a term which may extend to 1 year or with fine which may extend to 10,000 rupees or with both, and involves quantity lesser than commercial RI for a term which may extend to 10 years.
So 4.8 kg is a small quantity or intermediate quantity? Small quantity is 1 kg.
Intermediate also.
Intermediate
Small is 1
quantity.
kg.
So the punishment prescribed for the same is rigorous imprisonment for a term which may extend to 10 years. Minimum is not prescribed.
NMA is not prescribed.
So the person is already, he had already served 2 years, 5 months
5
in
months.
custody in Hazard jail. Hazard. So whether all the provisions were complied with, including section 42, 53.
Lordship, there are some discrepancies regarding the evidences actually from where they have possessed it. These things are there also, Lordship. So first I want to go through the evidence who had actually lost the Ajahar, because it is lost by one Mahila Morsha, Mahila Samiti, Lordship.
No, 52A, 42,
Lordship.
whether these sections were complied with. Kobe, where is the record of the trial court? Okay, you were going through it. You see the evidence of the IO.
I will also.
Yes.
May I read also?
Yes.
So this is on 5/7/16. I was working as second officer at Thola. On the day at about 4:30 p.m., the then OC Sri Ranjan Dole received a phone call from one lady, namely Swapna Maheshwari of Bormora Miri Pathar, and she had informed that the house of accused Torun Das was kept carried out by Mahila Samiti on account of finding suspected narcotic materials in his house. Accordingly, the then OC entered a GD entry being number 94 dated 5/7/16. He entrusted me to investigate the case. Exhibit 3 is the said GD entry. Exhibit 3(1) is the signature of the said OC, Sri Ranjan Dole. I visited the PO along with 4 numbers of battalion. I was also accompanied by OC Sri Ranjan Dole. Then I informed the matter over phone to the SP Sadia. The SP Sadia accordingly directed me to continue investigation. Then we searched the house of the accused in presence of Mahila Samiti members. We recovered about 4.8 kg of suspected ganja from the house of the accused Torun Das. Accordingly, I seized the same in presence of Mahila Samiti members. I brought a weight machine to Dagapalla and weighed the seized articles, which was 4.8 kg. Exhibit 2 is the seizure list. Exhibit 2.5 and 2.6 are my signatures. After weighting the seized article, I returned the weight machine Dagapalla to Sri Diganta Boragohai. Exhibit 4 is the Jimmanama. The suspected narcotic materials were divided into 3 parts of 25 grams each. Thereafter, signatures of witnesses and accused, including me, were obtained on the samples. Thereafter, I visited the place of occurrence and prepared the
No,
case.
where the sample was drawn up before the magistrate?
No, Lordship, at the
No.
place of occurrence.
The place of the suspected narcotic drugs were divided into 3 parts of 25 grams each.
It was not said.
Thereafter, signatures of witnesses and accused, including me.
Whether that inventory was prepared?
In his cross, he has stated that he had not even mentioned the place of seizure in the seizure list.
That is not exhibited, that means he is not.
No, that is not an exhibit.
Inventory not prepared. And samples were not drawn up before the magistrate.
It was,
And whether these articles are exhibited before the trial court.
No, Lordship. And the samples prepared by me were sent for FSL Guwahati through additional report. Exhibit 3, 6, and 7 are FSL report, the result of the report. That is not also there.
the FSL expert was also not examined. And from whom he had collected the weigh machine, he was also not examined as a witness, although he stated that he had taken signature of witnesses, but the person from who he had the IO had taken the weigh machine, Diganta Buragohain, his statement was also not recorded.
Mm.
And in his seizure list, he had not mentioned the place of seizure also.
Inventory not exhibited, Lordship, thereafter, Lordship. It is also not identified in the, as per the receipt, Lordship, it is not identified in the.
Search warrant was not there. He had not taken a statement of any of the nearby villagers. So only.
Let us do one thing. You go to the record and you see whether this section 52A and other provisions are complied with or not by the IU. And recently we have delivered one judgment sitting in division bench. Perhaps 3 weeks back, you find out that judgment. Sitting with Justice Manish Chaudhary, we have delivered one judgment of NDPS Act. There, this compliance of this section 52A has been discussed, was discussed. You find out a copy of the judgment and you see the requirement of compliance of section 52A. We'll fix it on next Tuesday. Heard in part. No, heard is B. Sharma, learned amicus curiae. Then Mr. P.S. Lofer, learned additional PP for the state respondent. Place the matter on next Tuesday for further hearing.
13th. Item number 6.
Main feature Lordship.
Mm.
For 3 substantive question of law was framed. One earlier on 18/12/13, the question of law was framed was whether title suit number 106 on 18/12/13 first, whether the title suit number 106 is maintainable in view of the provision contained in Order 9 Rule 9 CPC. As earlier suit being title suit number 75/1979 was dismissed for default. In other words, whether for the same cause of action, a fresh suit is maintainable when the earlier suit was dismissed for default. And again, at the time of hearing recently, on 21/5/24, another question of law was framed. Whether the learned court below were justified in decreeing the suit in favor of the plaintiff in absence of any document of title being exhibited in accordance with law, and whether the findings arrived at by the learned trial court that the plaintiff has right title and interest of the suit property suffers from perversity in view of the evidence on record. This is the 3 substantive question of law framed by the court. The facts of the case is that you'll see I filed a additional affidavit on 18/6/24 because in the translate type copy of there is some error mistake. So I freshly filed. It is filed on 18/6/24 by way of affidavit. You'll also see the plain.
So there are 2 substantial question of law.
Three. On 21/5/24, at the time of hearing, this honorable court has another 2 substantial question of law. On
The
21/5/24.
first one is in page number.
First is on dated 18/12/13. This is at the time of admission.
18/12/13.
And last one, so at the time of hearing, the
Yes.
honorable, on 21/5/24, another two subsequent question was framed.
And thereafter you file additional affidavit.
Yes, on 18/6/24, because in the, at the time of filing the memo of appeal, the translate type copy of the plain and written statement, there is some mistake. So the honorable court has directed me to file a fresh one.
Now the matter is ready for hearing.
Lordship, I'm ready.
Lordship, the engaged counsel is not yet reached your lordship. Lordship, meeting will pass next week, your lordship.
Who is your engaged counsel?
The SP Chaudhary, your lordship. A brief of in hand, your lordship.
Your good name?
PK Mehta, your lordship. I am also in this case, your lordship.
Learned counsel appearing on behalf of Mr. S.P. Chaudhary, learned counsel for the respondent. With consent from the other side, press for listing the matter on when?
22nd August.
22nd.
Thursday. Number 7.
So the appellant is absent on several dates.
Several dates, my lord.
What to do?
My lord, it can be dismissed of if your lordship pleases. What they call that.
Pardon me, sir, your good name?
N. Chaudhary.
Learned counsel for the respondent. None appears for the appellant on call. Mr. Chaudhary referring to the order dated 7/12/2023, 14/9/2023, 22/8/2023 submits that the appellant remain unrepresented consecutively for 3 dates. And as such, Mr. Chaudhary submits that the matter may be dismissed for default. Perusal of the record indicates that on 7/12/2023, 14/7/2023, no, 14/9/2023, 22/8/2023, the appellant remained unrepresented. In view of the above, this court find no just ground to adjourn the case to another date, and accordingly the same is dismissed for default.
Deeply obliged.
Item number 10. We are responding.
Appellant absent.
Absent, my lord, but instead of dismiss for default, that may be fixed and last chance may be given, my lord.
Last chance.
Yes, my lord. Otherwise, again, my lord, it will delay, my lord. They will file restoration petition again. So, my lord, some date may be fixed, my lord. We have, on the basis of our application, the case is listed for hearing, my lord.
None appears for the appellant on call. However, Mr. Your good name, please.
I'm PS Deka, my lord.
P.
PS Deka.
Yes,
the
learned
correspondent.
counsel for the respondent. The learned senior counsel, assisted by learned counsel for the respondent present. It appears that so, no, list the matter on, when can be listed?
Next week, no, 18 August. Last week of August, on 27th August.
27.
Okay, ma'am.
On subsequent non-representation of the appellant before this court, appropriate orders shall follow.
Good. Number 11.
Your lordship, maybe kindly take another day, your lordship. So on next, your lordship, then 20, your lordship, next.
Yes.
It may be fixed on next, your lordship, 20, your lordship.
Why?
Some have some problems, your lordship, today, your lordship.
Yes, Mr. Rosewater.
Up to him, my lord. I am the defense. His suit was dismissed.
Acha.
So suit, there is want of necessary party not maintainable. The burden of proof he has not been able to prove. These evidences, witnesses has supported my case in the cross. So ultimately, there exists nothing.
This is not your lordship. We have the case. We are the possessor, owner of the plot of land, your lordship. He is not the owner of the plot, your lordship. So I have the case, your lordship. That is why, your lordship, one kindly fix a date, your lordship, 20. I shall order. I shall move the
Okay.
property.
On the pair being made by Mr.
My lord,
Your good name?
R.M. Chaudhary.
RF.
Chaudhary.
RM Sodure, learned counsel for the appellant, with concern from the other side. Prespo listing the matter on
20, your lordship.
20.
My.
Okay. The pair having not been objected by learned counsel for the respondent. Allowed. Place the matter on 20.
Mass of
Number 12.
May I please your lordship? My humble submission is that, my lord. Present appellant is the defendant, my lord. And suit was dismissed, my lord. Thereafter, my appellate court reversed the findings, my lord. So, my lord, simple fact is that, my lord, plaintiff's predecessor of plaintiff, my lord, he purchased land from our predecessor, my lord. Subsequently, my lord, through another deed, my lord, during his lifetime, he transferred the land in favor of the defendant, my lord, present appellant, my lord. Now that deed is Exhibit 6, my lord. That has been challenged by the plaintiff, saying that it is a fraudulent deed, my lord. So, in order to establish that it is a fraudulent, my lord, whether they have sufficiently proved, my lord, through evidence, my lord, that is the question, my lord. My lord, trial court has rightly decided that in their evidence, they have brought nothing, my lord,
nothing about this validity of this deed, my lord, that it is a fraud, my lord. But appellate court has simply giving reason that that particular deed during before selling to the defendant, my lord, the predecessor of the plaintiff, he sold to another third person a part of that land, my lord. So the appellate court is saying that for total land 14 kathas, my lord, 3 kathas was sold to one third person, according to plaintiff, my lord. Appellate court is saying that there remains only 11 kathas of land. How can plaintiff side sell 14 kathas to defendant, my lord? Doubting that quantity is reduced, they cannot validly transfer 14 kathas since 3 kathas already sold to someone else, my lord. So on that presumption, my lord, on that presumption that appellate court has held that this deed is invalid, my lord, void, my lord. So that much, my lord. So if lordship go by evidence, my lord, I can establish that.
That's all
appellate
right,
court
but the other side? Who was the advocate?
that timing, my lord, it might be kept timing, let them come.
Timing. Okay.
Number 13.
Lordship, this appeal is against the judgment and decree passed in title appeal 10 of 2015, Lordship.
You were ready? Ready to argue the matter?
Yes, Lordship.
Yes, other side?
Lordship,
Where is the substantial question of law?
order 21-3-7.
Order dated 21/3/2017. Yes.
In this matter, plaintiff who are the respondent here in the appeal had jointly possessed a plot of land measuring 1 katha described in Schedule A.
Yes.
All the plaintiffs have separately bought the land and they have registered their name in the right of records separately, Lordship. So, Lordship, but they have filed a plaint jointly. That is one of the ground, Lordship, for our appeal, Lordship. They cannot do that, Lordship, because they have purchased the plot of land separately, Lordship. Lordship, and further, Lordship, the suit land was not properly identified. The appellate court below ought to have got the suit land properly identified, Lordship, before passing the impugned judgment, Lordship. Further, Lordship, if Lordship, the learned court below have decreed the suit only on the basis of the commission report.
Yes.
The report, Lordship, was not properly prepared, Lordship. The only they did not measure the land properly, Lordship.
Next.
And Lordship, in their plaint, they have not mention of giving the position of the land to them.
Lordship, if Lordship sees page number 63 of the appeal, Lordship.
Page number 63 of which record?
Lordship, of my petition, RSA.
Page number 50?
63, Lordship.
63. Yes.
Lordship, paragraph number 4. That the plaintiff number 1 has purchased a plot of paragraph number 4, Lordship. The plaintiff number 1 has purchased a plot of land measuring 5 leases from so and so. The original pattatar through a registered sale deed having Abhayapuri sub-register number so and so dated 22 to 2000. That just after the purchase, the vendor delivered the actual possession of a to plaintiff number 1. That the plaintiff number 2 has also purchased a plot of land measuring 5 leases from the above noted Nipendas Height sale deed number so and so dated 22 to 2000. That the plaintiff number 3 has purchased a plot of land measuring 5 leases from the above stated Nipendas Height registered sale deed so and so. Abhayapuri sub-register office dated 22 to 2000. That the plaintiff number 4 also purchased a plot of land measuring 5 leases from the aforesaid Nipendas through a registered sale deed of Abhayapuri sub-register so and so. That all these plaintiffs have been possessing 1 quota of land jointly compromising 1 plot. But Lordship, plaintiff number 2 and 3 and 4, they have not mentioned that they have their position was delivered to them, Lordship. So there might be a discrepancy in the plot from the very beginning, Lordship. That should have been properly measured while
Commissioner.
Yes, Lordship, by the Commissioner, Lordship. And Lordship, plaintiff number 4 have specifically stated in his clause that he is not dispossessed of his land, Lordship. These are the grounds, Lordship. These are the grounds, Lordship. That's all, Lordship.
Any other point? No. Yes, madam. Your correspondent number?
All the
All the
respondents.
respondents.
1, 2, 3, Lordship.
Yes,
We are the plaintiffs, Lordship. Our case.
before the trial court.
Yes, Lordship. We are the plaintiff. We filed a suit that, Lordship, we have purchased the suit property by different registered sale deeds. And thereafter, the defendant encroached over 5 leases of land, Lordship. So
Encroach.
Encroached, Lordship. So our prayer
You have purchased.
through different sale deeds, Lordship, we have exhibited.
So what was the
Our prayer, page 64, Lordship, for a declaration that the plaintiffs have the right title interest over the land of Schedule B, and also for a declaration that the land of Schedule B is a part of Schedule A land. For khas possession for evicting the
page
defendant-
number? You were reading page number?
64, Lordship. That was our prayer before the Munsif, Lordship, in our suit, Lordship.
Yes.
for a declaration that the plaintiffs have the right title interest over the land of Schedule B, and also for a declaration that the land of Schedule B is a part of Schedule A land. For khas possession, for evicting the defendants from the land of Schedule B, for permanent injunction against the defendants from raising any pakka structure upon the land of Schedule B, for any other reliefs as the plaintiffs are entitled in law and equity. They denied the case of the plaintiff lordship. Thereafter, during trial lordship, one Amin commission was appointed. And accordingly, Amin commission lordship submitted report saying that 3.5 lesser was under the defendant's possession lordship. And trial court formulated lordship from issues page 18 lordship. On the basis of the pleadings of both the parties, trial court formulated 4 issues lordship.
Page number?
18 lordship. Trial court judgment starts from page 14, relevant issues lordship page 18.
Yes. 4 issues.
Yes, lordship. Is the suit is undervalued and stamped? It was already in our favor, lordship. Is the suit is bad for non-joinder of necessary parties? That is also in our favor, lordship. Is the plaintiffs has the right title and interest over the suit land and also entitled to get khas possession of the same? What reliefs the plaintiff is entitled, lordship? So on the basis of these issues, lordship, Amin commission was appointed.
Where is the report of the Amin commission?
Lordship, relevant issue number 3, I will read, lordship, page 20. That is the finding by the learned trial court, lordship.
Yes.
PW1 deposed that he, along with plaintiff number 1, 2, and 4, is the joint owner of a plot of land measuring 1 kata more fully described in the Schedule A of the plain. The defendants have their land in the eastern side of the aforesaid land. The plaintiff number 1 purchased 5 lessa of land by registered sale deed number 410 from one Nipen Das, and the possession of the aforesaid land was immediately delivered to the plaintiff number 1. The plaintiff number 2 has also purchased a plot of land measuring 5 lessa from Nipen Das by registered deed number 413, and possession of the aforesaid land was immediately delivered to plaintiff number 2. The plaintiff number 2 died issueless, and hence he became the owner of the aforesaid land as husband. He has also purchased a plot of land measuring 5 lessa from the said Nipen Das by registered deed number 411, and the possession of the aforesaid land was immediately delivered to him. Further, plaintiff number 4 has also purchased a plot of land measuring 5 lessa from Nipen Das by registered deed number 412, and the possession of the aforesaid land was delivered to plaintiff number 4 on the same day. So, lordship, on the same day, 4 registered sale deeds were executed, lordship. Plaintiff 2 and 3 are husband and wife, lordship. So they have 2 registered sale deeds, and other 2 plaintiffs has 2 registered sale deeds. So total 20 lessa of land they purchased, lordship. The aforesaid land consists of 1 plot of land, and the plaintiff enjoyed the same jointly. The land was mutated in favor of the plaintiffs under Khatian number 717 old, Patta number 525, Miadi Khiras Patta number 290, Dag number 249. The plaintiffs accordingly paying revenue to the government regularly. After getting the delivery of possession, the plaintiff constructed a bamboo fencing on the aforesaid land. On 12/5/2000 at night time, the defendants encroached about 5 lessas of the plaintiff's land by breaking the bamboo fencing. During cross-examination, he deposed that although he, including the other plaintiffs, purchased the land separately, but they did not get the possession separately. So they get the possession, lordship, jointly. It's a joint compact area, lordship. PW2, the seller of the Schedule A land, corroborated PW1 and deposed that he was the owner of a plot of land measuring 1 kata situated at Abhayapuri town under Srijangam Revenue Circle covered by Khotian number so-and-so lordship. He sold the aforesaid land to the plaintiffs in equal proportion, that is 5 lessa each by registered deed number, these 4 deeds, lordship. And PW1 as Exhibit 3. PW1 as Exhibit 3 shows that the patta was issued jointly to the plaintiffs in respect of the Schedule A land. So, Lordship, Lordship, PW2 is the vendor of the plaintiffs, Lordship. Next, page 22. Immediately delivered the possession to them. The said 1 katha of land was jointly possessed by the plaintiffs, but the defendants on 12/5/2000 encroached about 5 lessa of the plaintiff's land. During cross-examination, he deposed that the possession of the Schedule A land was not delivered part by part. The possession was delivered jointly. So, Lordship, owner is also, Lordship, proving the case of the plaintiffs, Lordship. PW3 Sureshwar Majumdar, the plaintiff number 4, deposed that he and the other plaintiffs purchased the Schedule A land from Nripen Das. He proved the registered sale deeds bearing number so-and-so in his favor and 410 of 2000 executed in favor of his wife, that is the plaintiff number 1 as Exhibit 7. And during 7 and 8, during cross-examination, he deposed that his plot of land has no connection with the boundary of defendant's land. Defendant has not dispossessed him from his plot of land. He did not properly read his evidence on affidavit, and his counsel has not explained the contents of his evidence on affidavit. DW1 defendant number 3A deposed that he has right title, interest and possession over the Schedule B land. The suit land is the part of their plot of land measuring 1 katha 5 lessa covered by so-and-so lordship. Under Srijangam Revenue Circle, DW2 and DW3, Sri Shashodhar Pal also corroborated the DW1 in this regard. Now, first of all, PW1 and PW3 has successfully proved the sale deeds by number so-and-so as Exhibit 1, 2, 7 and 8 respectively. Further, also the PW2, the seller has proved his signatures on so-and-so. Vendor examined lordship, he proved his signatures. The copy of the Miyadi Patta, which has been proved by the PW1 as Exhibit 3, shows that the Patta was issued jointly to the plaintiffs in respect of the Schedule A land. The copy of the revenue received dated so-and-so, which has been proved by PW1 and PW3 as Exhibit 5, shows that the revenue in respect of the Schedule A land has been paid by the plaintiff number 4. The copy of the demarcation certificate dated 15/1/2001 issued to plaintiff number 4 by Assistant Settlement Officer Abhayapuri, which has been proved by PW1 and 3 as Exhibit 4, shows that the Schedule A land has been demarcated and boundaries are confirmed by the concerned revenue circle. The report also shows that the portion of land of the defendants encroached by the Abhayapuri Wholesale Consumers Cooperative Society Limited. The landholding certificate dated so-and-so issued by the Assistant Settlement Officer Abhayapuri to the plaintiffs, which has been proved by the PW1 as Exhibit 9, shows that the Schedule A land has been jointly mutated in the names of the plaintiffs. Hence, from the aforesaid discussion, I am of the opinion that plaintiffs has their right title and interest over the Schedule A land. Secondly, the documents proved by DW1 as Exhibit A, B, C, D, E, and F, which does not belong to the Schedule A land. The documents are in respect of a plot of land measuring 1 katha 5 lessa covered by Patta number 718-1127 new, Dag number 1246 and 250 new, which in my considered opinion, definitely not the suit land. Thirdly, Schedule B land, which is the part of Schedule A land over which the defendants claim their right title interest, has failed to establish the same through evidence. Moreover, the plaintiffs has established their right title interest over the Schedule B land. DW4 Sri Deepak Chandra Rai, Latmandal of Srijangam Revenue Circle, in his evidence deposed that the plot of land covered by so-and-so has been surveyed by concerned Latmandal. After the survey, a report has been submitted. The report has been proved as Exhibit G. Further, on the basis of the said report, Circle Officer of Srijangam Revenue Circle submitted a report which has been proved as Exhibit I. During cross-examination, he deposed that survey was done on the basis of a notice issued by this court. The notice has been proved as Exhibit 10. From the contents of Exhibit I, it could be seen that out of the total 1 katha of land of the plaintiffs, 16 lessa of land has been under the possession of the plaintiffs. 3/4 lessa is footpath and 3.25 lessa of land is under the possession of the legal heirs of deceased defendant Krishna Narayan Kakoti. Hence, from the evidence of DW4, it could be easily determined that defendant number 1A to 1E are in illegal possession of the plaintiff's land measuring 3.25 lessa. From the aforesaid evidence, it is also came to light that actual measurement of the Schedule B land is 3.25 lessa. In view of the aforesaid discussion, I have no hesitation in holding that the plaintiffs has right title and interest over the suit land and they are entitled to recover the class possession. Therefore, this issue is decided in affirmative in favor of the plaintiff. In view of the discussion held in issue number 3, I hereby held that the plaintiffs are entitled for following reliefs. It is declared that the plaintiffs has right title interest over the Schedule B land and the Schedule B land is a part of Schedule A land. The plaintiffs are also entitled to recover the khas possession of a portion of land measuring 3.25 lessa, which is a part of Schedule B land by evicting the defendant. So my suit was, Lordship, partly decreed. In order portion, the suit is decreed partly on contest with cost. So my prayer was for, Lordship, recovery of 5 lessa. It was after report, Lordship, given to 3.25 lessa. And we are, Lordship, not disputing that part. On the basis of that report, suit was, Lordship, decreed. Furthermore, Lordship, on the basis of all the sale deeds and the revenue documents, Lordship.
So originally your pair was for 5 lessa,
5 lessa.
but the court had awarded
Given only 3.25 lessa, as Lordship, a part of that land was given to footpath, Lordship. 3/4 lessa is footpath. And plaintiff, Lordship, they have cross-examined Lordship, the Deepak Chandra De Lotmandal as DW4 defendant.
DW4 is a Latmandal.
Yes, Lordship. They cross-examined DW4, Lordship. They, Lordship, after being satisfied on the cross-examination, the suit was decreed, Lordship. And now their substantial question of law is that whether only on the basis of that Amin Commission report, the plaintiff suit can be decreed. Both the courts held that, Lordship, the plaintiff has right title interest, and from the report, and it is proved that the lands are in illegal possession of the defendants, Lordship. So
There is concurrent finding.
yes, Lordship.
the-
Concurrent title appellate judgment also in favor of the plaintiffs, Lordship. Page 49, issue number 3 by the first appellate court, Lordship.
Page number
49, Lordship. The issue number 3 is the main issue, Lordship. It is relevant to decide the right title of the plaintiff and whether they are entitled for recovery or not, Lordship. Page 49 of the appeal memo.
yes.
Issue number 1 relates to the question of, Lordship, wrongly written as 1, right title interest of the plaintiff over the suit land. It should be issue number 3, Lordship. And whether the plaintiff is entitled to recover khas possession of the same. The learned trial court holding that the plaintiff has right title interest over the suit land arrived at a finding that the plaintiff are also entitled to recover possession of the suit land. Learned trial court relied on the report of commission appointed for the survey of the suit land to arrive at the aforesaid finding. PW1, one of the plaintiff asserted in his evidence in affidavit that plaintiff number 1 is a joint owner of the suit land along with plaintiff number 1, 2, and 4, and that he had purchased the suit land by registered sale deed number so-and-so and secured possession of the same. PW1 also testified that plaintiff number 2 had also purchased another plot of land by registered deed number so-and-so, and that is PW1 himself also purchased land measuring 5 lessas from Nipen Das by registered deed number so-and-so, and plaintiff number 4 also purchased a plot of land measuring 5 lessas from the original owner by registered deed number so-and-so, and secured the delivery of possession of the same on the said date, and that the plaintiff had also obtained patta in respect of the suit land and had mutated their names in the records of rights in respect of the suit land. PW3 also deposed in tune with PW1. PW2, the original owner of the suit land, admitting the execution of registered sale deeds, averred that he had jointly delivered the possession of the purchased land. PW1 and PW3 had exhibited Exhibit 1, 3, 7, and 8 being the registered sale deeds in reference. Execution of the sale deeds have been proved by PW2 by identifying his signatures on exhibits. PW1 also exhibited Exhibit 3 being the patta in respect of the A schedule land. PW1 and 3 has identified the revenue receipts in respect of the suit land as exhibit. Perusal of Exhibit 3, which is a patta and which has remained unchallenged, is a document of title under the Assam Land and Revenue Regulation, and the same goes on to show that the plaintiff joint title over the suit land. That the possession of the suit land was jointly delivered was not disputed by the defense. Though there is an existence of separate title, yet the title to the suit land have remained joint as the suit land has remained unpartitioned between the co-owners, that is plaintiffs. Accordingly, I am but to hold that plaintiff has right title interest over the Schedule A land. DW1 has exhibited Exhibit A being the landholding certificate, Exhibit B being the certified copy of Jamabandi, Exhibit C being trace map, Exhibit D being the patta in respect of the land covered by DAG number 250, patta number 336, and Kacha patta Exhibit F in respect of patta number 1127 old and 324 new, and DAG number 250 new for land measuring 1 katha 5 lesa. The suit land schedule in the plaint is land covered by patta number 717 old and 525 new. So the DAG number and patta numbers are completely different, lordships. And DAG number 1245. The said documents exhibited by the defendant do not pertain to the suit land and is of no aid to the defendant's side. The plaintiffs have right title interest over the Schedule A land. The defendants had claimed that the Schedule B land as their own land, but the documents exhibited by the defendant's side do not support their claim. On the other hand, Lot Mondal, who had been examined as DW4 in a connection with the survey of the suit land, which was directed to be done at the instance of the parties in the suit, have proved the report of the Survey Commission as Exhibit G and the report of the Circle Officer as Exhibit I. Perusal of the said reports being Exhibit I and G discloses that 3.25 lesas of land belonging to the plaintiff had been found to be under the possession of the legal representative of defendant Krishna Narayan Kakoti since deceased, while 3/4 lesa is included in a footpath. The plaintiff side though had disputed the Exhibit I and G but failed to show in what manner the report of survey is rendered bad in law. It is not hesitated that the survey knowing commissioner so appointed had no knowledge or expertise to conduct the survey of the suit land. Hence, the survey reports are accepted and acted. Judgment of the Honorable High Court rendered in the case of Gitarani Dhar and others reported in 2015 3 GLT 282 is apposite to be referred herein. Their lordships had held therein that when Survey Commission report is not indicative of where the encroached land is, no decree could be passed for recovery of the same. But in the instant case, the Survey Commission report clearly indicates the extent of encroachment of plaintiff's land by the defendant, for which same could be directed to be recovered. The alleged encroachment as claimed by the plaintiff stands proved on the basis of the survey reports being Exhibit I and Exhibit G. Thus, the decision of the learned trial court in respect of the present issue is correctly arrived. So, Lordship, there is no substantial question of law, Lordship. They cannot prove that both the courts wrongly, Lordship, decreed the suit of the plaintiff on the basis of Survey Commission. And Lordship, regarding commissions, Lordship, there is a procedure. They can sought for cancellation of that report and they can again pray for second commission if they are not satisfied at the trial stage, Lordship. That was not done by the defendants. And now at the second appellate stage, Lordship, that substantial question will not come in this case, Lordship. as per order 26, rule 9, Lordship. Commissions to make local investigations. In any suit in which the court deems a local investigation to be requisite or proper for the purpose of elucidating any matter in dispute, or of ascertaining the market value of any property, or the amount of any money profit or damages, or annual net profits, the court may issue a commission to such person as it thinks fit, directing him to make such investigation and to report thereon to the court, provided that where the state government has made rules as to the persons to whom such commission shall be issued, the court shall be bound by such rules. In this case, Lordship, at the instance of the parties, Amin Commission was directed. It is not a case that court itself directed for Amin Commission, Lordship. So they got opportunity to cross-examine the Lot Mandal, Lordship. They got opportunity to even challenge that order. That was not done by the defendants, Lordship, at the time of trial, Lordship. Procedure of commissioner is provided in Rule 10, Lordship. The commissioner, after such local inspection as he deems necessary, and after reducing to writing the evidence taken by him, shall return such evidence together with his report in writing signed by him to the court. Report and depositions to be evidence in suit. The report of the commissioner and the evidence taken by him, but not the evidence without the report, shall be evidence. So it's a part of record, Lordship, in the suit and shall form part of the record. But the court or the permission of the, or with the permission of the court, any of the parties to the suit may examine the commissioner personally in open court, touching any of the matters referred to him or mentioned in his report, or as to his report, or as to the manner in which he has made the investigation. So they got ample opportunity to cross-examine that witness, Lordship, and even they got ample opportunity to challenge that order also, that commission report. They have not, Lordship.
The Amin Commissioner was examined as witness.
Yes, Lordship.
PW?
If they are not satisfied, Lordship.
No,
they-
PW? He was examined
Yes, Lordship, DW4, Lordship.
for PW4.
By the defendant, they examined him. Lordship. Defendant examined him as DW4, Lordship.
DW4.
Yes, Lordship. There is one more provision, Lordship, sub-rule 3 of Rule 10, Lordship, where the court is for any reason dissatisfied with the proceedings of the commissioner, it may direct such further inquiry to be made as it shall think fit. So if they are not satisfied with the report, they can pray before the court immediately to the learned trial court that we are not satisfied with the report of the Amin Commission. So, Lordship, we may be permitted for second Amin Commission. There are, Lordship, opportunities to them, Lordship. That was not done, Lordship. And now, after Lordship, two courts' decision, now they are taking this substantial question of law that whether on the basis of only report, the suit can be decreed or not. Not only on the basis of report, Lordship, on the basis of all the sale deeds, jamabandis, and by the evidence of
Cell deed is exhibited as
Exhibit 1, 2, 7, and 8, Lordship.
1, 2, 7, and 8.
8, Lordship.
And Jamabandi?
Jamabandi, Lordship. Page 26, your Lordship will get.
Page number?
26, Lordship. Appendix is there, Lordship. Exhibit 1 is the original copy of the registered sale deed. 2 is original copy of the registered sale deed. 7 is the original copy of the registered sale deed. 8 is also the original copy of the registered sale deed. So 4 registered sale deeds we have exhibited. Landholding certificate, Exhibit 9. And Exhibit 10, notice issued by this court for survey of suit land dated 28/5/2014. An original copy of the Miadi Patta Lordship Exhibit 3. Exhibit 4 is the certificate of demarcation. Our lands were demarcated and thereafter possession was handed over, Lordship. Revenue receipt, Lordship, present revenue receipt dated 11/9/2000. And certified copy of Jamabandi Exhibit 6. Everything was exhibited by the plaintiff's, Lordship. So on the basis of all these original documents and revenue records, Lordship, suit was decreed. In addition to the only disposition part was, Lordship, decided on the basis of the survey commission, Lordship. Thank you. First appellate court cited one decision, Lordship, 2005 GLR page 2, Lordship. For your Lordship.
That was in respect of
Lordship, Amin Commission.
Amin Commission report.
Yes, Lordship. Paragraph 13, 14 are relevant, Lordship. Paragraph 13, it discussed about the identification of the suit land, Lordship. Paragraph 13 says, Lordship, it has been held by the Honorable Apex Court in the case of Pratibha Singh and another versus Santi Devi Prasad and another reported in 2003 to SCC 330 that non-compliance of the requirement of Order 7 Rule 3 CPC cannot be a ground to defeat a decree passed by the court in favor of a party. Paragraph 17 of the said judgment is quoted herein below for ready reference. When the suit as to immovable property has been decreed and the property is not definitely identified, the defect in the court record caused by overlooking of provisions contained in Order 7 Rule 3 and Order 20 Rule 3 CPC is capable of being cured. After all, a successful plaintiff should not be deprived of the fruits of decree. Resort can be had to Section 152 or Section 47 CPC, depending on the facts and circumstances of each case. Which of the two provisions would be more appropriate, just, and convenient to invoke? Being an inadvertent error not affecting the merits of the case, it may be corrected under Section 152 CPC by the court, which passed the decree by supplying the omission. Alternatively, the exact description of decretal property may be ascertained by the executing court as a question relating to execution, discharge, or satisfaction of decree within the meaning of Section 47 CPC. A decree of a competent court should not, as far as practicable, be allowed to be defeated on account of an accidental slip or omission. In the facts and circumstances of the present case, we think it would be more appropriate to invoke Section 47 CPC. From the above, it is clear that although the plaintiff has failed to give specific description of the area of land under encroachment, yet from the report of the survey commissioner, it is apparent that 14 lessees of land is under encroachment. Since the encroachment of the aforesaid 14 lessees of land pertains to the Schedule A land, hence the decree passed by the learned First Appellate Court cannot be executed in any manner so as to disturb the possession of the defendant over the Schedule B land under his possession. In other words, it is made clear that in purported execution of the decree passed by the learned First Appellate Court in title appeal number so the possession of the defendant over any portion of the Schedule B land cannot be disturbed. With the above observation, this second appeal is disposed of. So even this is not the case in my case, as because, Lordship, we have already identified the suit land in our plane, and accordingly, as per report also, it is identified the how much land disposes the defendant's Lordship. So the exact area of land under the possession of the defendants was already reported by the Amin Commission. So as per report also, it is reflected that 3.25 lessa is under the possession of the defendant's lordship. So that may be recovered, and both the courts decreed the suit of the plaintiff lordship.
Okay.
So my humble submission, lordship, there is no such substantial question of law arises in this appeal, lordship. And the concurrent finding of both the courts below, lordship, in favor of the respondents.
Yes, any reply?
My reply is only that the issue number 3, it is mentioned that they have anywhere in issue number 3, the possession was granted. It was mentioned that possession was granted, but in their claim, they itself have said that have not mentioned about that, lordship. Only one of the plaintiff have mentioned that his possession was given. That's all, lordship.
Okay. Heard, Mr.
Shi Sharma, lordship. Shi Sharma.
Learned counsel for the appellant and also heard Ms. R. Chaudhary. Learned counsel for the respondent. Argument concluded, order reserved, judgment reserved.
And deeply approved.
Could you look, Edward? Item number 14.
Next week or any day, may given.
Yes. Any objection? Mr. Ahmed, learned counsel for the appellant with consent from the other side, press for listening the matter on
After 15, any day,
29.
29. Hello.
Fair Lord.
May I please, lordship? I am extremely sorry, my lord. As regarding item number 7, my lord, I was in another court on legs, my lord. In the matter, your lordship is pleased to dismiss the appeal, my lord, second appeal for default, my lord. I have informed the other side, my lord, that case may kindly be destroyed, my lord, may hard, my lord. Item number 7, my lord. This one,
You adopt the course available. We have already passed the order. What is the point for recalling the order?
I am sorry, my lord, because I was on legs, my lord, that's why I could not appear on time, my lord.
You follow the procedure.
Timing item number 12.
Please, your lordship, my lord. This appeal is against reversal findings, my lord. My lord, if you read that first, my lord, trial court finding, my lord, the lordship may kindly turn to page 41, my lord. How trial court has dismissed the suit, my lord, on what ground, my lord? Page 41, my lord. What is for page 42, my lord? It is a suit for.
Page number 41.
Yes, my lord. It starts from page 42, my lord.
Yes.
This is a suit for declaration of title confirmation and possession of and cancellation of sale deeds. Plaintiff's case in nutshell is that the second RS Patta number 27 was originally issued in the name of the predecessor of the defendant, namely.
So, what is the substantial question of law here?
Substantial, yes, my lord. Substantial question of law, my lord. So, admitted on. Admitted on 22 February 2016, my lord.
Order
Whether the
dated
minor-
22.
22 to 2016. Whether the learned lower court appellate court below was justified in drawing an adverse presumption under section 114 of the Indian Evidence Act against the present appellant defendants, despite the failure of the prosecution side to discharge its burden of proof. Whether the learned lower appellate court below was correct in interfering with the findings of the learned trial court below by holding cell deed number so exhibit 6 as a fraudulent one, whereas it is admitted from pleading of the plaintiffs that they could know about the said cell deed on 5/11/1990 only when they obtained the certificate copy of the cell deed from the concerned authority. So, my lord, two substantial questions of law. One is, my lord, drawing of adverse presumption, whether learned appellate court was correct, my lord. That is one. And second one is whether exhibit 6 is a fraudulent or not, my lord. So exhibit 6 is most vital document, my lord. That is to be decided, my lord. Now, my lord, how trial court has decided, my lord. That is on page 42, my lord.
Yes.
The plaintiff's case in nutshell is that the second arrest patta number 27 was originally issued in the name of the predecessor of the defendant, namely Sudhanna Mohan Raha. That while Sudhanna Mohan Raha was owner and possessor of the suit patta, he sold 13 kathas of land to the predecessor of the plaintiff, namely Madhusudan Pal, by registered sale deed. That is admitted, my lord. That subsequently, the predecessor of the plaintiff also purchased 1 katha 3 chatak 10 gonda of pathway type land on the predecessor of the defendant. That is also admitted, my lord. Thereby, the predecessor of the plaintiff purchased total land 14 katha 3 chatak 10 gondas from the predecessor of the defendant. That the said pathway type of land is situated on the adjacent eastern boundary of the earlier purchased land of 13 kathas. The predecessor of the plaintiff sold 3 kathas of land to one Shankar Ranjan Das and delivered possession to him. According to plaintiff, my lord, they sold 3 kathas to one Shankar Ranjan Das. He is PW3, my lord. Therefore, the predecessor of the plaintiff remain owner of 11 katha 3 chatak 10 gondas of land. Madhusudan Pal died on 13/9/1997, leaving behind the plaintiff as his sole heirs, who became the owner of the above land by way of right of inheritance. That on the death of husband, the plaintiff number 1 left the suit premises along with his sons and started residing elsewhere in search of avocation. The plaintiff occasionally visits the suit premises and maintaining the suit land by putting bamboo fencing around it. He also sells the sungrass grown on the suit land. Accordingly, on 1/6/2005, when the plaintiff, by engaging labor putting bamboo fencing around the suit land, the defendants opposed the said work and tried to attack the plaintiff with lethal weapon. The plaintiff, apprehending the danger, immediately apprised the matter to the nearby people, and they came and rescued the plaintiff and secured that the defendants had fled away. And seeing the defendants fled away, but they leave with a warning that they will come again. The plaintiff also informed the matter to the Gaon Panchayat. Subsequently, the plaintiff compelled to file proceeding under section 144 CRPC. That the aforesaid act of the defendant clouded the right title and interest of the plaintiff. In that proceeding, the plaintiff surprisingly come to know that second party allegedly purchased the whole land from the predecessor of the plaintiff by registered sale deed. That is exhibit 6, my lord. The plaintiff obtained a certificate copy and come to know about the sale. The plaintiff claimed that his predecessor, except the land of 3 kathas, never sold any land to any person. The so-called sale is forged and fraudulent. Hence, he filed this suit. Now, on summons, the defendant appeared in the suit and filed written statement. The defendant denied all the allegations of the plaintiff. The defendant admits that the predecessor of the plaintiff, Madhusudan Pal, purchased total land of 14 katha, 3 chatak, 10 gondas of land from the predecessor of the defendant, Sudhanna Mohan Raha. The said Madhusudan Pal transferred the land to the defendant number 2 for valuable consideration. That is exhibit 6, my lord. And since then, the defendant number 2 is possessing his purchased land. The defendant claimed that his purchase deed is valid and genuine, and the plaintiff, fully knowing the real fact, making false statement at the instance of the persons inimical to the defendant, and filed the instant false suit. Hence, the defendant prayed to dismiss the suit. So, my lord, by true deed, my lord, plaintiff's predecessor purchased land from the defendant's predecessor, my lord. Then, my lord, through one document, my lord, one sale deed, again, plaintiff's predecessor sold the entire 14 kathas of land to defendant number 2, my lord. So now they are challenging that this selling again back to us, that exhibit 6 is fraudulent, my lord. That is the case. Now it is to be seen whether plaintiff side has abundantly proved that it is fraudulent or not. That is to be seen, my lord. There are altogether 7 issues, friend, my lord. Out of this, issue number 4, 5, 6, these are very vital, my lord. 4 says whether plaintiff has right, title, and interest. 5, whether the plaintiff has possession over the suit land. 6, whether the sale deed registered on 4/12/1990 is illegal, fraudulent, and liable to be cancelled. Discussion, decision, and reason for such decision. Issue number 4, 5, and 6. As these 3 issues are very vital issues and interrelated to each other, so these 3 issues are taken together for discussion. It is admitted fact that the petitioner of the plaintiff Madhusudan Pal purchased total area of 14 katha, 3 chatak, 10 gondas of land from the petitioner of the defendant Sudhamna Mohan Raha. But the bone of contention is that the plaintiff alleged that on the death of husband, the plaintiff number 1 left the suit premises along with his sons and started residing elsewhere in search of avocation. Plaintiff occasionally visit the suit premises and maintaining the suit land by putting bamboo fencing around it. He also sell the sungrass grown on the suit land. Accordingly, on 1/6/2005, when the plaintiff, by engaging labor putting bamboo fencing around the suit land, the defendant opposed the said work and tried to attack the plaintiff with lethal weapon. The plaintiff, apprehending the danger, immediately apprised the matter to the nearby people, and they came and rescued the plaintiff. And seeing that the defendant had fled away, thereafter the plaintiff come to know that the defendant allegedly purchased the whole land from the petitioner of the plaintiff by registered sale deed. The plaintiff obtained a certificate copy and come to know about the sale. The plaintiff claimed that his predecessor, except the land of 3 kathas, never sold any land to any person. The plaintiff claimed that the said purchase is illegal and fraudulent. On the other hand, the defendant claimed that predecessor of the plaintiff sold out the suit land to the defendant number 2. Plaintiff appeared as PW1 and deposed in support of her claim. But in the cross-examination, this is very important, my lord, but in the cross-examination, she could not answer the relevant question, which is very vital in the suit. PW1 in her cross replied that she cannot say if the defendant has submitted their written statement or not. She cannot say anything in respect of this suit, except the sale to Shankar Ranjan Das. She cannot say the suit patta number, the total land of the suit patta, who possessing what land. She cannot say anything about the subject matter of the suit. About the subject matter of the suit also she cannot say. PW2 in his cross replied that he cannot say as to who filed the case. He cannot say in whose favor he come to depose. So these 2 witnesses, my lord, they don't know anything about the suit, my lord. The suit land is situated at a distance of 2.5 kilometers from his house. He cannot say who is possessing how much land in Dudhpatil. He is deposing as per version of his auntie-in-law. From the cross-examination of PW1 and 2, it is crystal clear. Auntie-in-law means, my lord, PW1, my lord. That is plaintiff number 1. From the cross of PW1 and 2, it is crystal clear that they do not know anything about the suit. During argument, learned counsel for the plaintiff submitted that the case of the plaintiff is proved as per the document, and as the defendant has not come to the witness box, so he avoided pertinent question which would be asked by the plaintiff. In the light of this fact, the case of the plaintiff should be decreed. Learned counsel for the defendant submitted that the plaintiff must prove his case by leading evidences. Defendant relied on citation reporting AR 1956, Supreme Court 66. I perused the citation of the Honorable Apex Court, held that a true judicial decision presupposes an existing dispute between 2 or more parties and then involves 4 requisites. The presentation of their case by the parties to the dispute, if the dispute between them is a question of fact, the ascertainment of the fact by means of evidence adduced by the parties to the dispute, and often with the assistance of argument or by on behalf of the parties on the evidence. If the dispute between them is a question of law, the submission of legal argument by the parties, and a decision which disposes of the whole matter by a finding upon the facts in dispute and an application of the law of the land, the facts so found, including where required a ruling upon any disputed question of law. It is established law that the party on whom the burden of proof lies shall adduce the evidence in support of his case to prove the fact of the case. When a witness deposed in support of his case, then to check the veracity of his statement, the other side is given the opportunity to cross-examine the witness to shake the credibility of the witness. The examination in chief as well as cross-examination together form the evidence basing on which the court is to come to a proper conclusion. In this suit, the plaintiff claimed that she has right title and confirmation of possession and for cancellation of sale deed, but her deposition in chief has been fully destroyed in the cross. There is no scope left for the court to accept what the plaintiff deposed in her examination chief. In the light of above discussion, I therefore held that the plaintiff could not establish her case by leading sufficient evidence, nor she could establish that the sale deed is a fraudulent and illegal. Hence, I opine that the plaintiff has no right title and possession over the suit land. And the plaintiff also failed to establish that the sale deed is not illegal or fraudulent. All these issues, 3 issues are answered in the negative and decided against the plaintiff. So, my lord, these are the findings given by trial court. Now, if we go by the findings of the appellate court, my lord, let us check what appellate court has said, my lord. Appellate court finding is page 55, my lord.
50?
55. You start from page 56, my lord. In the first part, my lord, facts are recorded, my lord. Page 57, my lord. If we during the trial, paragraph 5, my lord. During the trial of the suit, the plaintiff side adduced evidence to PWs and exhibited some documents. The defendant adduced none. Upon closure of both sides' evidence, the learned court heard argument and by passing the impugned judgment and dismissed the suit of the plaintiff. Agreed by and disagreed with such dismissal, the plaintiff preferred this appeal. During pendency of this appeal, the appellant side adduced additional evidence, my lord. During appellate stage, my lord, and the PW3, that is, my lord, the respondent side took full scope for cross-examination. Upon closure of additional evidence, I have heard argument advanced by learned advocates of both sides. There appears no dispute to the fact that by 2 documents, Exhibit 1 and 2, Madhusudan Pal, the predecessor of the appellant's plaintiffs, purchased 14 Katha, 3 Chata, 10 Gondas land in the suit patta and Dag from Sudanna Mohan Raha, the predecessor in interest of the respondent's defendant. In the suit where the appellant's plaintiffs claim that their predecessor sold 3 katas of land to one Shankar Ranjan Das. Shankar Ranjan Das is the PW3, my lord, who deposed at the appellate stage, my lord. And his evidence is also very important, my lord. And did not sell any other land. The respondents, defendants claimed that the Madhusudan Pal sold his entire interest of 14 kathas, 3 chatak, 10 gondas in favor of respondent defendant number 2 by registered deed number 845. Thus, the crux of the dispute between the litigating parties is over the question whether the registered deed number 845 is fraudulent or not. Hence, the following point is taken up for determination. Point for determination whether the deed number 845 is a fraudulent or not. Discussion, decision, and reason thereof. In the suit, the plaintiffs have prayed for a decree of declaration of their right, title, and interest over suit land, suit schedule 1 land, confirmation of possession thereon, and cancellation of registered deed number 845. The plaintiff side has proved in the record the purchase deeds of their predecessor Madhusudan Pal by Exhibit 1 and 2. These documents are original registered sale deeds dated 5/8/86 and dated 13/10/87 respectively. Exhibit 1 and Exhibit 2 are undisputed documents. Exhibit 1 shows transfer of right, interest, title, interest, and possession of 13 kathas land, and Exhibit 2 shows transfer of 1 katha, 3 chatak, 10 gondas, in total 14 kathas, 3 chatak, 10 gondas of land in the suit patta, and that's within specific boundaries by the predecessor in interest of the defendants in favor of the predecessor in interest of the plaintiffs. The plaintiffs have also exhibited the original sale deed executed by Madhusudan Pal on 12/5/87 in favor of Shankar Ranjan Das by Exhibit 3, my lord. My lord, this point, my lord, I want to point out that original was not exhibited, my lord. Xerox copy was exhibited. From record, may find it, my lord. So, plaintiffs have also exhibited the original sale deed.
Original of this deed number 845 was not exhibited.
My lord, 845 deed is Exhibit 6, my lord.
Original.
This what I am saying is, this is Exhibit 3, my lord. That is, my lord, Madhusudan Pal, he sold 3 katas to 1/3 person, my lord. Third person is PW3, he came to witness box, my lord, during appellate stage, my lord. So I am saying that, my lord, they have not, the court has wrongly recorded that original sale deed was executed. It was Xerox, my lord. So I am coming, my lord. The plaintiffs have also exhibited the original sale deed exhibited by Madhusudan Pal on 12/5/87 in favor of Shankar Ranjan Das by Exhibit 3. Exhibit 3 is duly proved by Shankar Ranjan Das himself. After acquiring title of about 13 kathas land in the Shoot Patta and Dag, the predecessor in interest of the plaintiffs transferred by sale 3 kathas of land in the Shoot Patta and Dag in favor of Shankar Ranjan Das by Exhibit 3. So after sale, Madhusudan Pal's interest is reduced to 10 kathas on 12/5/87. Thereafter, on 13/10/87, Exhibit B said Madhusudan Pal purchased another 1 katha, 3 chatak, 10 gondas in the Shoot Patta and Dag from the predecessor interest of the defendants. And after such purchase, his total interest is increased from 10 kathas to 11 katha, 3 chatak, 10 gondas on 13/10/87. In between Exhibit 1 and 2, my lord, Exhibit 3 was dealt with. So, my lord, ultimately, according to them, my lord, he was having only his increase from 10 kathas to 11 kathas, 3 chatas and 10 gondas. Thus, it appears after sale to Shankar Ranjan Das, Madhusudan Das was having right title, interest and possession about 11 kathas, 3 chatak, 10 gondas of land in the Shoot Patta and Dag on 13/10/87. The registered document of number 845 is proved in the record by Exhibit 6. Exhibit 6 shows sale of 14 kathas, 3 chatak, 10 gondas of land in the Shoot Patta and Dag by Madhusudan Pal in favor of defendant number 2 on 5/11/1990. This Exhibit 6, they are saying that this is fraudulently obtained by law. We have already seen above that on 13/10/87, Madhusudan Pal's right title in interest and possession in the Shoot Patta and Dag was reduced from 14 katha, 3 chatak, 10 gondas to 11 katha, 3 chatak, 10 gondas. In such a situation, by Exhibit 6, right title, interest and possession over 14 katha, 3 chatak, 10 gonda cannot be legally transferred by Madhusudan Pal in favor of defendant number 2. On the other hand, the answering defendants have not come up with any evidence in support of their claim of purchase of the scheduled mentioned land of the WS from Madhusudan Pal, my lord. Learned Appellate Court is holding that, my lord. Since Madhusudan Pal was not having 14 kathas of land, how can he sell 14 kathas? According to Appellate Court, he was having 11 kathas, 3 chatak and 10 gondas of land. So if he sold more than that amount of land, that means this is fraudulent, my lord, on presumption, my lord. My lord, if he has cheated me, then is it the ground for doubting my deed, my lord? I'm already being cheated, my lord. He said it is 14 kathas, I trusted, I purchased, and accordingly, my lord, court is taking presumption that, my lord, since I have not come to witness box, my lord, so that means that is fraudulent, my lord. Since there was only 11 kathas
Exhibit
of land.
6. Exhibit 6 is fraudulent.
Exhibit 6, madam. Now, my lord, where Madhusudan Pal had no right title, interest and possession over 14 kathas of 3 chatak, 10 gondas of land in the Shoot Patta and the Dag, the Exhibit 6 cannot convey right title, interest and possession over 14 kathas, 3 chatak, 10 gondas of land in the Shoot Patta. And in the absence of proof of execution of such document by Madhusudan Pal, we are left in no hesitation that the said document is fraudulent. So this is the reasoning given, my lord. In absence of proof of execution of such document by Madhusudan Pal, my lord, that is a registered deed, my lord. Deputy registrar has signed, my lord. I am coming to the evidence part, my lord, later, my lord. The learned advocate of the defendant respondent vehemently argued that where the cross-examination of all the PWs, including the plaintiffs number 1, has exposes their ignorance, it is enough to reduce the suit to the ground. Refuting the argument, the learned advocate for the appellant plaintiff argued that oral evidence in a civil suit is not as much material as the documentary proof, and the learned court committed illegality in not taking into consideration the documents proved in the record. Bearing in mind the argument, if we go through the evidences on record, it is found that in a suit where right title and interest is subject matter of dispute, oral evidence has little weight in determining the fate of the suit. Rather, the documents proved in the record will prevail over the oral evidence, and ignorance on the part of the PWs regarding the suit and the suit land has little bearing in deciding the fate of the suit. A perusal of the impugned judgment, it transpired that it is not discussed and relied upon the documentary proof in arriving at a decision of the suit. The whole approach by the lower court appears to be not sustainable in the eye of law. Where the plaintiffs by documentary proof have been able to establish the fact that on the date of alleged execution of Exhibit 6, the vendor did not have right, title, interest, and possession over 14 katas. Again, repeating same thing, my lord. 14 katas, 3 chatters, 10 katas of land. It was the duty of the defendant respondent to adduce evidence proving execution of the said deed by Madhusudan Pal, or that on the date of execution of Exhibit 6, the vendor had right, title, interest, possession over those 14 katas, 3 chatters of gondas, 10 gondas of land, my lord. So also burden, my lord, initial burden has to be discharged by the plaintiff, my lord. They have not discharged their burden, my lord. So onus has not been shifted to defendant, my lord. Rather, the defendant respondent did not appear in the witness box to prove their case. In the case law reported in AR 1973, Guwahati 90, relied upon by appellant plaintiffs, it is held that when a party to suit avoids the witness box, the presumption is that he is withholding himself to avoid pertinent questions in cross-examination. In this case, also where the defendants claimed right, title, interest, and possession over the suit scheduled land by purchase from Madhusudan Pal, they ought to have adduced evidence proving execution as well as genuineness of Exhibit 6, but they refrained themselves. In such a situation, an adverse presumption lie against their case under Section 114 of Evidence Act. Accordingly, we are left in no hesitation that the Exhibit 6 is an illegal and fraudulent document. As such, the point in hand is decided in the affirmative. Admittedly, Madhusudan Pal was having right, title, interest, and possession over 14 katas, 3 chatters, 10 gondas of land in the Sutpatta and Dag. It is proved in the record that out of said 14 katas, 3 chatters, 10 gondas, he transferred by sale 3 katas of land in favor of one Shankar Ranjan Das. So after such sale, he had right, title, interest, and possession over 11 katas, 3 chatters, 10 gondas of land in the Sutpatta. Exhibit 6 being proved in record to be fraudulent and liable to be cancelled, the plaintiffs as legal heirs and successor of deceased Madhusudan Pal have right, title, interest, and possession over 11 katha, 3 chatters, and 10 gondas of land in the Sutpatta Down. So it appears that the impugned judgment and decree are liable to be inferred. So this reasoning, my lord. Now let us go to the evidence, my lord. What evidence PWs has stated, my lord, in their evidence, my lord? There are 3 PWs, my lord. PW 1, 2, and 3, my lord. But I am having cross part, my lord. So if I read the cross part, my lord. PW 1, Pratibha Sundari Pal. She is plaintiff number 1, my lord. Wife of Madhusudan Pal. On oath. This is Bengali, my lord, I am reading. I mean, total.
Page number? You are referring to page number?
Page, my lord, page, it is.
You have not enclosed it in the appeal?
Not Record, my lord. Record, my lord, not NS, my lord.
Gotcha. Evidence of
PW 1, my lord. Pratibha Sundari Pal, my lord. In their cross examination, my lord. It is in Bengali, I am reading, my lord. আমি আমি ছোট লেখা পড়িতে পারি না। Cross part, my lord.
Okay. Evidence. See to it. Exactly. Yes.
Yes, my lord. প্রতিভা সুন্দরী পাল, that is PW1, my lord. On oath, my lord, cross examination. আমি ছোট লেখা পড়িতে পারি না। আমি আজ থেকে 12 বছর যাবৎ চোখে দেখি না। আমি ক্লাস 6 পর্যন্ত লেখাপড়া করিয়াছি। আমি ইংলিশ লিখিতে পড়িতে পারি না। Now this is very important, my lord. আমি শঙ্কর রঞ্জন দাসের 12/5/87 12/5/87 নং তারিখের দলিলের জেরক্স কপি দাখিল করিয়াছি। She exhibited, this is exhibit A, Xerox copy, exhibit 4 mark করা আছে। এটা this is my lord exhibit 3, my lord, wrongly stated exhibit 4, my lord, exhibit 3. This deed of selling to Shankar Ranjan Das, that is 12/5/87, is exhibit 3, my lord. She is admitting that she has submitted Xerox copy of that deed, my lord, but no reason assigned for non exhibiting original, my lord. আমি সরকারি চালানের জেরক্স কপি দাখিল করিয়াছি আর এক্সিবিট 8 সিরিজ হিসাবে মার্ক করিয়াছি। ওই এক্সিবিট 4 আর এক্সিবিট 8 আমার বড় ছেলে জেরক্স করিয়াছে। এক্সিবিট 3 কোনো সার্টিফিকেট কপি আমি বাহির করি নাই। এই মোকদ্দমায় বিবাদীরা জবাব দিয়েছে কিনা আমি জানি না। আমি শঙ্কর রঞ্জন দাসের নিকট বিক্রয় করা ছাড়া এই মোকদ্দমা সম্পর্কে কোনো কিছুই বলিতে পারিব না। She has admitted, my lord, except knowing that the part of land was sold to Shankar Ranjan Das, she has no idea about the suit land. এই মোকদ্দমার জমির পট্টা নং আমি বলিতে পারিব না। নালিশা পাট্টায় মোট জমি কত, কে কোন জমি দখল করিয়া আছে তাহা আমি বলিতে পারিব না। দুধপাতিল হইতে আমার বাসস্থান গুঙ্গুর আনুমানিক 14 মাইল দূরে। 2 নং বাদী 2-3 বছর যাবৎ গুয়াহাটিতে কর্মরত। আমরা বাদীরা এই মোকদ্দমার বিষয়বস্তু কিছু বলিতে পারিব না। She and even her other plaintiffs, they know nothing, admitting that nothing about the suit. আমি প্রফুল্ল রাহাকে চিনি, আমি বিনয় সরকারকেও চিনি। ইহা সত্য নয় যে আমি যেটার জেরক্স কপি এক্সিবিট করিয়েছি তাহা আইনমত গ্রহণযোগ্য নয়। That means exhibit 3, my lord, xerox copy submitted in suggestion, my lord, it is stated that this is not a fact that the xerox copy exhibited by me, exhibit 3, my lord, that is not acceptable in law, my lord. So this much evidence from PW1, my lord. Nothing about our exhibit 6 doubting whether it is genuine or fraud, my lord. Nothing from her evidence, my lord. Nothing, my lord. Absolutely nothing. She's saying that we sold Shankar Ranjan a part of the land. That is what we know and nothing more than that. So this is her evidence. Now, if we go to PW2, my lord, PW2, Chandan Dushar, in his cross-examination, what he said, my lord. আমি যে জমি নিয়ে সাক্ষী দিতে আসিয়াছি সেই জমির স্থান দুধপাতিল বাজারি ছাড়া আমার নিজস্ব কোনো জমি নাই। মধুসূদন পালের সঙ্গে আমার কি ধরনের আত্মীয়তার সম্পর্ক তাহা আমি আমার মুখ জবানে বন্দিতে উল্লেখ করি নাই। এই মোকদ্দমা কে করেছে আমি বলিতে পারিব না। এই মোকদ্দমার কি কি কাগজপত্র দাখিল হইয়াছে তাও বলিতে পারি না। আমি কোন দলিলের সাক্ষী নই, আমি কোনো দলিলের সাক্ষী নই। আমি অত্র আদালতে কার পক্ষে সাক্ষী দিতে আসছি তার নাম বলিতে পারিব না। For whom I have come to court to give evidence, I do not know. So this is the evidence, quality of evidence, my lord. Lordship may kindly consider, my lord. দুধপাতিল বাজারি চড়া আমার বাসস্থান হইতে 2-2.5 কিলোমিটার দূর। আমি ইংরেজি লেখাপড়া জানি না। আমি আমার পিসি শাশুড়ির কথায় কোর্টে আসিয়া সাক্ষী দিতেছি। PW1, my lord, পিসি শাশুড়ি। On her behalf, my lord, on her request, আমি আমার পিসি শাশুড়ির কথায় কোর্টে আসিয়া সাক্ষী দিতেছি। এই মোকদ্দমা সম্পর্কে আমার ব্যক্তিগত কোনো জ্ঞান নাই। I have no personal knowledge about the suit. So these two PW1 and PW2, my lord. They are evidence, my lord. Now, during appellate stage, my lord, PW3 was examined. That is, my lord, he is Shankar Ranjan Das, who purchased the alleged land, my lord, a part of the land, my lord. What he said in his cross-examination, this is also important, my lord. PW3 Shankar Ranjan Das. It is in English, my lord. I am reading.
Yes.
I used to stay at Bilpar, Silchar town permanently with my family members. I am staying in a rented house under Radha Madhav Akhara, Bilpar. I have no document to show that I am a monthly tenant of Radha Madhav Akhara. I cannot read and write English. I can read Bengali. I was not present at the time of hearing of the original suit. I was taken to lawyer by Pratibha Rani Pal, PW1, my lord, plaintiff number 1. I was taken to lawyer. The examination in chief is written at the instance of Pratibha Rani Pal. Chief was written at the instance of Pratibha Rani Pal, not on his behalf, my lord. It was the person of Pratibha Rani Pal. Exhibit 1 is the sale deed of Madhusudan Pal. I have mentioned in my examination in chief that exhibit 1 is dated 8586. In exhibit 1, the date of execution is written as 5886. I cannot say the holding number of rented house in which I am residing with my family members. I cannot say the total number of dags of the suit patta. I cannot say the total area of land covered by suit patta. I cannot say the area of land possessed by different persons in the suit patta. I cannot say the area of land covered by suit dag. This is important now, my lord. I cannot say the deeds in respect of which I have stated in my examination in chief. Even the purchase deed, he purchased deed exhibit 3. He's saying that I cannot say the deeds in respect of which I have stated in my examination chief. So also he is not aware of his purchase deeds, my lord. Now, how it is proved that London Appellate Court has recorded that, my lord, that what it is? The plaintiff has also exhibited the original sale deed of Madhusudan Pal in favor of Shankar Ranjan Das. Exhibit 3 is duly proved by Shankar Ranjan Das himself. Appellate Court is recording that Exhibit 3 is duly proved by Shankar Ranjan himself. And in evidence, Shankar Ranjan, he is saying that I cannot say the deeds in respect of which I have stated in my examination. I have no idea about the deeds in respect of the suit, my lord. So in the deed through which he purchased 3 kathas of land, he is also not aware of that. Then how it is proved, my lord? Appellate Court has stated this, my lord, that it is duly proved. Exhibit 3 is duly proved by Shankar Ranjan himself, my lord. So, my lord, perversity, my lord, absolutely perverse, my lord. So now I am not attesting witness of any of the deeds I have mentioned in my examination chief. I cannot say whether my examination chief was written by hand or it was typed. I cannot say whether and how my examination chief was written. So, my lord, only these 3, basing on these 3 evidence, my lord, Appellate Court has reversed the findings, my lord, doubting that the Exhibit C is a fraudulent one. My lord, no one has said anything about Exhibit 6, my lord. Not a single word, my lord. Whisper, my lord. Nothing. No, my lord. I am relying on 2 citations, my lord.
Yes.
Yes, my lord. That one is, my lord. One is on Gujarat High Court, my lord. It says that, my lord, person who had misrepresented the other person and had persuaded him to purchase the land for consideration and sold land to him cannot challenge the sale deed executed by him to be void, as it would amount to taking benefit of his own fraudulent act in executing the sale deed, my lord. So, my lord, at this stage, plaintiff cannot take the stand, plea that is fraudulent. They are cheating me by selling only 11 kathas and saying that it is having 14 kathas, my lord. And now they are taking the plea that it is fraudulent, my lord. That here, my lord, in this particular case, my lord, court has said that plaintiff cannot challenge in a similar situation, my lord, plaintiff cannot challenge. Well, paragraph 8 is important, my lord. Lordship may kindly see paragraph 8. We have considered the submission advanced by the learned advocates appearing from the respective parties. Firstly, Article 137 of the Limitation Act would apply in the facts of the present case, which provides for the maximum period of 3 years for filing revision, and therefore it cannot be said that the void order can be challenged at any point of time because delay confers no title and its validity can be questioned at any stage. But the moot question would be, who can challenge a void order? In our opinion, a person who has misrepresented the other person had persuaded him to purchase the land for consideration and sold the land to him can challenge the said order, void order, but it is not open for him to challenge the sale deed executed by him to be void, as it would amount to taking the benefit of his own fraudulent act in executing the sale deed, knowing fully well that the said sale deed could not be executed by him. So if any fraud is played by plaintiff's side, they cannot take advantage of that fraud, my lord. That is what it has said, my lord. Another case, my lord, that is on a different point, my lord, which says presumption, my lord. Regarding 114 presumption, London Appellate Court has drawn adverse presumption under 114 of Evidence Act, my lord. In this case, my lord, Supreme Court has said, my lord, Supreme Court has said, my lord, in paragraph 6, my lord, Lordship may kindly see paragraph 6.
Yes.
We find that the conclusion that there was a valid marriage between so-and-so, the father of the appellant, and so-and-so, the mother of the appellant, stand by the presumption of available in law, presumption available in arising out of the long cohabitation of so-and-so, so-and-so. The Privy Council in so-and-so, so-and-so case held that the law presumes in favor of marriage and against concubinage when a man and woman have cohabited continuously for a number of years. This court in so-and-so, so-and-so case held that the continuous cohabitation of a man and woman as husband and wife and their treatment as such for a number of years may raise the presumption of marriage. But the presumption which may be drawn from long cohabitation is rebuttable. And if there are circumstances which weaken or destroy that presumption, the court cannot ignore them. This is the thing, my lord. Now, my lord, whether, my lord, the circumstances of the present case, the evidence, whether such evidence has destroyed that presumption, my lord. Court cannot ignore this fact, my lord. Since I have not come to the witness book, that does not mean that, my lord, the entire burden presumption should be imposed on me, my lord. That it should be against me, my lord. Court cannot ignore them, the circumstances. Since plaintiff side has failed to discharge their preliminary burden, initial burden, so nothing can be presumed against me, my lord. So that court cannot ignore the circumstances also. That is what Supreme Court said, my lord. This much is my humble submission, my lord. And also, my lord, Exhibit 6 was a registered deed, my lord. Deputy Registrar has signed, put his thumb impression also. They could have brought him also in order to establish whether it was genuine or not, my lord. Since they are giving 3 witnesses and these witnesses are silent about Exhibit 6, my lord. The very vital document which is under challenge, my lord. And appellate court is only presuming that it is not having, since plaintiff is not having 14 katas of land, he is having only 11 katas of land, so he cannot sell 14 katas, more than 11 katas of land. What is this, my lord? How this logic is applicable here, my lord? I am being cheated, my lord. And moreover, my lord, Exhibit 3, that sold it to some Ranjan Das, my lord, that is also a Xerox copy, my lord. Why they have not furnished original copy exhibited, and no reason has been assigned for non-exhibiting original copy, my lord. So it is not admissible in law also, my lord. This is my last.
Yes. You are not audible.
Exhibited the original, my lord, the deed, my lord, PW3, my lord, the Shankar Ranjan, my lord. It is on record, my lord. Exhibit 5 is a petition, my lord, filed by the PW3, my lord. The Exhibit 5 is a in the record, my lord, that he has filed a petition, my lord, regarding the submission of the original sale deed, my lord. At the appellate stage, my lord. Though in the trial stage, it was not submitted. At the appellate stage, my lord, Exhibit 5 is a petition, my lord.
Exhibit?
Of the, my lord, PW3, Shankar Ranjan, my lord.
At appellate stage?
Appellate stage, my lord, his evidence is adduced, my lord, PW3.
PW3.
PW3, my lord. It is, my lord, admitted, my lord. PW3, Shankar Ranjan, my lord. Who purchased, my lord, the 3 kata land, my lord.
But where is that evidence?
Yes, my lord. His evidence, my lord, is my friend, my lord.
Do you have any copy with you? Yes.
My lord. Exhibit 5, my lord, it is mentioned a petition submitted by the Shankar Ranjan, my lord. My lord got it on.
Shankar Ranjan's affidavit is there, cross-examination is there, but his evidence adduced.
My lord, Exhibit 5 is a document, my lord. I have verified the record, my lord.
Exhibit 5.
Yes, my lord.
Okay. You show the document. Mark it in the file, relevant file. We'll resume it too. And in the meantime, this cross-examination of PW 1 and 2, can it be translated?
Yes, yes. Okay.
You can furnish it on a later date.
My lord. I think, my lord, it is required, my lord. We have not also provided the copies, my lord. It is required, my lord. I think, my lord, the translated copies, my lord, for the.
Okay, you complete the argument today.
Oblige.
If necessary, we'll adjourn the matter further.
Oblige.
So as to translate the evidence of PW 1, 2, and 3.
1, 2.
Cross-examination only.
Oblige.
Yes. So according to you, this exhibit 6, it was proved by PW3.
There is a petition, my lord, on record. I have found.
Pardon?
I have flag marked. I have flag marked in the first flag, my lord, first and second, that in response to a notice of the honorable court, first and second, first he submitted by a petition the original documents, and second is the number of sheets also mentioned of the documents. My lord. The notice was dated, my lord, 2011-06 on my record, my lord, but the court record I did not find the notice of the court to the PW3 Shankar Ranjan Das. There was a notice to produce the original sale deed. We purchased the 3 kata land from Madhusudan Pal, my lord.
Can it be said that this original deed is
As per
proved in accordance with law?
But as per record, I did not, my lord, find the original, my lord, or I have found a Xerox copy, my lord, in the record of the deed. But in the Xerox copy, my lord, there is,
It is perhaps a certified copy.
I think, but it is mentioned original, my lord. In the petition mentioned original, and in
Pardon?
the notice also, my lord, for production of the original sale deed, my lord.
Yes, so this is a certified copy.
Yes, my lord, maybe, my lord.
Hmm.
But this petition, my lord, it is mentioned that original, my lord. But what he produced, my lord, in the record, my lord, does not, my lord, reflect, my lord. Does not reflect that it is because it is not in the record, my lord. I have permission. So, my lord, this fact of selling the 3 kata land to the PW3 Shankar Ranjan, my lord, that is not disputed, my lord. There is no suggestion, my lord, either to the Shankar Ranjan, any of the witness, my lord, from the defendant side, that Shankar Ranjan did not purchase 3 kata land by deed number 1197 of 87, dated 12/5/87, my lord. Or Madhusudan did not sell this 3 kata of land by the sale deed 1197/87. Though in the WS, all the abatements had been, my lord, denied, but the WS has no evidentiary below because, my lord, the defendants did not enter the witness box. They did not, my lord, give their evidence, so the WS has no value, my lord. So it is admitted, my lord. Otherwise, if it is not the original, is not produced, the abatement is admitted, my lord. The plaintiffs, this sale of 3 kata of land, my lord. The learned appellate court, my lord, though the trial court based, my lord, the judgment only on the oral evidence of the plaintiffs, my lord, that they did not support the whatever they award in the evidence in chief. That is the trial court's finding, my lord. Your lordship already gone through the evidence, my friend, my lord, stated before the Honorable Court that there is ignorance on the part of the PWs, my lord, regarding the area of the land, the description of the land, all these, my lords. But this is a civil suit, my lord. The civil suit is mainly on documentary evidence, my lord. The documents are proved, my lord. The 14 kata, my lord, land is not disputed. The original land purchased by the predecessor of the, my lord, respondent plaintiffs from the predecessor of the defendants is not disputed, my lord. It is admitted 3 kata, 13 kata by Exhibit 1 on 5/8/86 by registered deed 2002/1986, 13 kata of land, and by registered deed number 1313 of 1987, 1 kata 3 sotak 10 gonda. That is total 14 kata 3 sotak 10 gonda land. It is admitted. And regarding the disputed, my lord, this 3 kata, this is the issue, my lord, that whether the predecessor of the plaintiffs, my lord, had validly transferred the land 14 kata 10 sotak, 3 sotak 10 gonda after selling 3 kata of land to Shankar Ranjan. My lord, the Shankar Ranjan purchased the 3 kata on 12/5/87 and the sale deed which is declared as void and illegal, my lord, it was of 4/12/1990 purchased by the defendants, my lord, by 8/45 of 1990. That is after selling of 3 kata land to Shankar Ranjan. So after selling the 3 kata land to Shankar Ranjan, Madhusudan Pal had the title over 11 kata 3 sotak 10 gonda land. Eleven kata 3 sotak 10 gonda land as on 4/12/1990. When the exhibit 6 was purportedly registered, my lord, 4/12/1990, the seller had the title of 11 kata 3 sotak 10 gonda and the transfer is 14 kata 3 sotak 10 gonda. So, my lord, the learned appellate court, my lord, may go to the second part of the findings, my lord. Again, my lord, if you lord, page number 59, my lord.
Page number
59, as per the
89
memo of appeal, my lord. It starts from 56, the facts, my lord, and finding, my lord, page number 59.
Yes.
My lord, page number 59. From 4th line, my lord, may I read, my lord? On the other hand, my lord, your lordship got it, my lord. Page 59 on the 4th line, my lord.
Yes.
On the other hand, the defendants have not come with any evidence in support of their claim of purchase of scheduled mention land of the WS from Madhusudan Pal, where Madhusudan Pal had no right title interest and possession over 14 kata 3 sotak 10 gonda of land in the Sweet Patta and Dag. The exhibit 6 cannot convey right title interest and possession over 14 kata 3 sotak 10 gonda of land in the Sweet Patta, and in the absence of proof of execution of such document by Madhusudan Pal, we are left in no hesitation that the said document is fraudulent. The learned advocate for the defendant respondent vehemently argued that where the cross-examination of all PW, including the plaintiff number 1, has exposes their ignorance, it is enough to reduce the suit to the ground. Refuting the argument, learned advocate for the appellant plaintiff argued that oral evidence in a civil suit is not as much material as the documentary proof, and the learned lower court committed illegality in not taking into consideration the documents proved in the record. Bearing in mind the argument, if we go through the evidence on record, it is found that in a suit where right title interest is subject matter of dispute, oral evidence has little weight in determining the fate of the suit. Rather, the documents proved in record will prevail over the oral evidence, and ignorance on the part of the PWs regarding the suit and the suit land has little bearing in deciding the fate of the suit. A perusal of the impugned judgment is transfers that it has not discussed and relied upon the documentary proof in arriving at a decision of the suit. The whole approach by the lower court appears to be not sustainable in eye of law, where the plaintiffs by documentary proof have been able to establish the fact that on the date of alleged execution of the Exhibit 6, the Bento did not have right title interest and possession over 14 kata 3 sota 10 gonda of land. It was the duty of the defendants respondents to adduce evidence proving execution of the said deed by Madhusudan Pal, or that on the date of execution of the Exhibit 6, the vendor had right title interest and possession over those 4 kata 3 sota 10 gonda of land. Rather, the defendants respondents did not appear in the witness box to prove their case. In the case law reported so and so relied upon by the appellant's plaintiffs, when a party to a suit avoids the witness box, presumption is that he is withholding himself to avoid pertinent questions in cross-examination. In this case also, where defendants claimed right title interest and possession over the suit scheduled land purchased from Madhusudan Pal, they ought to have adduced evidence proving execution as well as genuineness of the Exhibit 6, but they refrained themselves in such situation. Adverse presumption, that is the my lord substance question of law, this honorable court framed. Whether the learned appellate court, my lord, rightly taken the adverse presumption, my lord, as per section 114G. So, my lord, the finding of the learned appellate court is solely based on, my lord, may we go to the, my lord, section 114 of the Evidence Act, my lord. My
Yes.
lord, may I read, my lord, 114, my lord, of the evidence?
No, not necessary.
That was. So, my lord, the G said, my lord, that the evidence which could be and is not produced would, if produced, be unfavorable to the person who withholds it. So, my lord, they have withheld the evidence, my lord, without entering the witness box, my lord, and without producing the document, my lord. So, in this regard, my lord, I will submit, my lord, 3 judgments, my lord. Lalit Kumar, my lord, judgment is for the Delhi High Court, my lord. Paragraph 24, 25, may I read, my
এক minute.
Delhi High Court judgment, my lord. Page number 17 of the judgment, I have supplied, my lord. Page 24 and 25, my lord. Para 24, 25, my lord.
Page number?
17, my lord, 17.
Page number?
17, 17. I have marked the page. Para 24, my lord, a division bench of the Punjab and Haryana High Court, also in Bhagwan Das versus Vishan Chand and others, drew a presumption under section 114 of the Evidence Act that if a party does not enter into the witness box, an adverse presumption has to be drawn against that party. 25, applying the principles stated above to the instant case, it would be found that in the instant case also the appellant had abstained from witness box and had not made any statement on oath in support of his pleading set out in the written statement. An adverse inference has therefore to be drawn against him since it was specifically stated by respondent number 2 in his statement or note that it was at the instance of the appellant that he had issued the check on the account of the respondent 1 in the Central Bank of India, Sambalpur branch, and the appellant admittedly had encashed the check. An inference has to be drawn against the appellant that what he has stated in the written statement was not correct. In this circumstance, High Court was fully justified in declaring the suit of respondent in its entirety and passing the decree against the appellant. Next, my lord, the Calcutta High Court's judgment, my lord, page number 7. I will read two paragraphs, my lord. Paragraph number 10 and 12, page number 7.
Paragraph number
10 and my lord 12. Two paragraph I will read, my lord. Page number 7. My lord. In the paragraph 10, in the said case, the constituted attorney who adduced on behalf of the plaintiff seeking specific performance of the contract could not substantiate the readiness and willingness of the plaintiff to perform his part of the obligations under the contract, and the plaintiff himself did not adduce evidence in the suit. In the said factual context, the Supreme Court in the said case applied the adverse presumption under Section 114 of the Evidence Act to hold that where a party to the suit does not appear in the witness box and states his own case on oath and does not offer himself to be cross-examined by the other side, a presumption would arise that the case set up by him is not correct. Paragraph 12, my lord. In view of the provisions contained in section so and so, Evidence Act, I do not even find any infirmity in the decision of the land court below, rejecting the objection raised by certified copy of the registered power of attorney executed by the opposite party. So, my lord, the honorable court, my lord, in the light of the Supreme Court judgment, has, my lord, drawn the adverse, my lord, presumption. My lord, the last judgment, I will rely, my lord, the honorable Supreme Court judgment in Vidyadhar case, my lord, paragraph number 16, my lord, page number 7. May I read, my lord, paragraph number 16? Where?
Same principle, not required.
Same principle, my lord, Supreme Court, my lord, held, my lord. So, my lord, regarding this substantial question of law, my lord, number 1, my lord, there is no infirmity, my lord, in the findings of the learned appellate court below, my lord. In relying on the section 114G of the Evidence Act, my lord, and have my humble submission that, my lord, it is rightly held, my lord, that the sale deed is, my lord, is a void document, my lord, in the absence of the title of the seller, my lord. Number 2 of the substantial question of law, my lord, whether the learned lower appellate court below was correct in interfering with the finding of the learned trial court below by holding the sale deed as a fraudulent one, whereas it is admitted from the pleading of the plaintiff that they could know about the said sale deed number so and so only when the obtained the certified copy of the said deed. So it is a, my lord, question of fact regarding the knowledge of the, my lord, the plaintiffs regarding obtaining of the knowledge of the sale deed, my lord. So after knowing the sale deed, my lord, they have approached the, my lord, honorable court, and on the basis of the substantial question number 1, my lord, framed, this answer, my lord, this second questions, my lord, is based on the findings of the 1, my lord, substantial question number 1. So, my lord, my humble submission is, my lord, that there is no, my lord, infirmity in the honorable lower appellate court, my lord, in declaring the sale deed as void, my lord. This is my humble submission.
Yes, any reply?
My lord, defendant, although they have not deposed before the court, my lord, but in their WS, my lord, Lordship may kindly see the written statement, madam. Page 26, madam. Let's start from page 26. And operative part, page 28, madam, paragraph 15. Paragraph 15, page 28, madam. The statement made in para 5 of the plaint, it is submitted that Shankar Ranjan Das never possessed any land of the Sud Patta on the
You were
stand of-
reading paragraph number
Para 15, madam.
15.
Page 28.
Yes, yes.
That the statements as made in paragraph 5 of the plaint, it is submitted that Shankar Ranjan Das never possessed any land of the Sud Patta on the strength of deed number 1197 or otherwise. The said Shankar Ranjan Das is a necessary party to the suit, my lord. He was not made as a party also, my lord. Then lordship will kindly turn to page paragraph 19 also, my lord. Paragraph 19. Paragraph 18 and 19, my lord. Page 31, my lord. Page 31, my lord. Paragraph 18. The statements had made in so are absolutely false, baseless, malafide, and afterthought. The plaintiffs had full knowledge about the execution and registration of the sale deed number 845 of 1990 by Madhusudan Pal, predecessor of the plaintiffs, and they deliberately suppressing the same file case number so for wrongful gain. The said deed is a legal, valid, genuine, and operative deed, only duly executed and registered by said Madhusudan Pal to the full knowledge of all the neighboring people, including the plaintiffs. The said sale deed is not fraudulent as alleged. The plaintiffs are bound by the sale deed. The statement are made in the said para that the plaintiff number 1, after the said knowledge of the deed on 18/8/2005, inquired and later brought out a certificate copy of the deed number 845 of 1990 on 7/1/2006 and came to know its details for the first time about the said deed after going through it on the same date, that is 7/1/2006, and that prior to these days the plaintiffs had no knowledge about the deed are absolutely false, baseless, malafide, and afterthought. The plaintiffs had full knowledge about because the deed in question from the time of his examination and registration. Now, for the purpose of filing the suit and to avoid the bar of limitation, they have made out a false case of knowledge on 18/8/2005 and 7/1/2006. And again, next paragraph 19. The statement made in paragraph 9 of the plaint are also false, baseless, malafide, and afterthought. It is not a fact that the late Madhusudan Pal did not sell any other land out of his balance 11 kata, 3 chata, 10 gondas of land to anybody during his lifetime. Madhusudan Pal never transferred any land to Shankar Ranjan Das. It is not a fact that the defendants collusively and clandestinely executed and registered the sale deed in question in the name of wife of defendant number 1 by setting a fictitious person as Madhusudan Pal before the deputy registrar's office at Silchar and got it registered in collusion and witness and deed writer. The sale deed in question is a legal, valid, and genuine document. It was duly executed and registered by the said Madhusudan Pal personally appeared before the registration office. The allegation against the deed in question as made in the plaint are not only false, baseless, and malafide, but also afterthought for wrongful gain. Then, my lord, paragraph 20. With regard to the statement made in para 10 of the plaint, it is submitted that the suit land was never in possession of the plaintiff by right of inheritance or otherwise. The predecessor of the plaintiffs during his lifetime for valuable consideration transferred the suit land to the defendant number 2 by executing a legal, valid registered sale deed, and as for the plaintiffs, nothing to inherit on the date of their predecessor. Lordship may kindly thank you. Paragraph 26, my lord. Real facts. 26A. This is important, my lord. Page 35, my lord. Real facts. The predecessor, page 35, paragraph 26A. The predecessor of the plaintiff is Madhusudan Pal during his lifetime by registered deed dated 5/8/86 and 13/10/87 purchased a total area of 14 katas, 3 chatas, 8, 10 gondas of land as fully described in the schedule below from since deceased Sudendra Mohan Raha, father of the defendant number 1. While the said Madhusudan Pal was in possession and enjoyment of the land as described in the schedule below, accordingly on the strength of said purchase, he for valuable consideration transferred the same to the defendant number 2 by executing registered deed number 845 and delivered possession to the defendant number 2 on the date of sale. And since then, the defendant number 2 has been possessing and enjoying the land as described in schedule below as of her own right openly on the strength of her said purchase. The said deed was written by deed writer Debabrata Pal at the instance of both the parties. The said Madhusudan Pal was known to the scribe Debabrata Pal from before the writing of the said deed number 845. After writing the said deed, the scribe read over the same to the executant Madhusudan Pal, who being fully satisfied upon receipt of the consideration money in full in cash, executed the said deed by putting his signatures on all the pages of the deed in the presence of the scribe, defendants, and also attesting witnesses Nagendra Kumar Dev. Nagendra Kumar Dev is now dead. He was a resident of the same village where Madhusudan Pal was residing during his lifetime. And accordingly, Madhusudan Pal was known to Nagendra Kumar Dev long before the execution and registration of the deed. Thereafter, attesting witness Nagendra Kumar Dev in the presence of Madhusudan Pal, defendants, and the scribe, put his signature on all pages of the said deed as attesting witness. Thereafter, the defendant number 1, in the presence of parties to the deed, Nagendra Kumar Dev and the scribe put his signature on all pages of the deed as attesting witness. Thereafter, the scribe, in the presence of the parties, the dead and the attesting witnesses, put his signature on all pages of the deed as scribe. Madhusudan Pal was next door neighbor of the defendant. Madhusudan Pal registered the said deed by personally appearing before the deputy registrar, Silchar, where he was duly identified by defendant number 1. At the time of registration, Madhusudan Pal, in the presence of the scribe and defendants, also the deputy registrar put his signature and thumb impression on the backside of the first page of the deed. So, my lord, attesting witnesses also not examined. My lord, deputy registrar, official witness, my lord, court could have called him also, my lord. But no process has been initiated like this, my lord, and simply relying on PW 1, 2, and 3, my lord, simply they are also not aware of anything, my lord. Can a deed, registered deed, be cancelled like this, my lord? And moreover, my lord, Shankar Ranjan Das, PW 3, in his cross-examination, he is admitted that he is ignorant about his purchase, my lord. All the deeds, I have no idea, knowledge about all the deeds, including his deeds also. He is admitting, my lord. And he is also admitting that he came to the court at the instance of the plaintiff number 1, my lord, on behalf of plaintiff number 1, in persuasion of plaintiff number 1, my lord. Now, my lord, again, adverse presumption would come, my lord, as my learned friend has cited, my lord, would have been arisen, my lord, if the initial burden had been, my lord, discharged by the plaintiffs, my lord. Here, my lord, plaintiffs has absolutely failed to discharge his initial burden, my lord. Once initial burden has not been discharged, my lord, onus cannot be shifted to defendant, my lord. So defendant may not have come before the witness box, but that does not mean that, my lord, that it is the whole case is proved, established, the plaintiff's case is established. Not, my lord. They have to discharge their initial burden. So plaintiff has absolutely failed to discharge their initial burden. And as regards the exhibit 6, my lord, they could not establish anything regarding doubting its genuinity, my lord. It is a genuine document, my lord. Registered deed, my lord. Registered deed cannot be cancelled like this, my lord. So this is my humble submission. Moreover, my lord, there have to be, my lord, whether it was compared with the original or not, my lord, that is also a question, my lord.
So in the meantime, let the registry translate this cross-examination of PW 1, 2, and 3. We'll fix a very short date.
I will give tomorrow, my lord. I will give tomorrow.
You.
It will be better, the registry will, my lord.
Registry, yes.
Registry
Yes.
will-
Heart, Mr. Your good name?
I.S. Laskar.
I.S. Laskar, Learned Counsel for the appellant, and Mr. M.J. Kadir.
Yes.
Learned Counsel for the respondent. List the matter on COVID. 1 week. 2020. And in the meantime, registry shall make necessary arrangement for translation of the cross-examination of PW 1, PW 2, and PW 3.
My lord, can it be on 22, my lord? I have other matters on 20, my lord. Can it be on 22, my lord?
22.
22nd.
Okay, 22 obliged. 22. হেৰি কেইটা ওলাই দিব এইকেইটা। Part. Recital is the matter as parted.
Item for withdrawal. Item number 1 from production list.
There's a formal defect also, I. Like
Heard Mr. D there, learned counsel for the petitioner. Mr. Day submits that he has the instruction to withdraw this petition. Where is accordingly allowed. This transfer petition stands disposed of on withdrawal. Liberty.
Liberty to violate that.
However, liberty will remain with the petitioner to approach this court again by filing appropriate petition.
Item number 15.
And for the respondent, my lord.
Where is the appellant?
I know the names have been shown in the cause list.
None appears for the appellant on call, however, Miss
N. Upadhyay, my lord.
N. Upadhyay, learned counsel for the respondent present. Places release the matter
My lord,
after
will kindly fix a date, my lord.
On 27th.
27 in the event of subsequent non-appearance of the appellant. Appropriate order shall follow.
Oblige me.
Item 16.
Lordship, my senior is on legs at court number 2, your lordship. Lordship may hear the appellant. She is on legs at court number 2, your lordship.
Are you ready to argue the matter?
Otherwise, lordship may fix a date on some other date.
When?
Otherwise, also I'll
Court number 2 does say item 30. So yes, okay.
let us proceed then.
When?
He wants to proceed with,
Acha.
he wants to submit his
No,
argument.
lordship, if she comes, then I can proceed, but if she doesn't come, then I think.
He's
another
on legs, your lordship, court number 2, your lordship.
Whether he will be able to appear today?
Lordship, I don't think so because the matter is still going on, your lordship, court number 2.
Okay, we'll see later on. Wait.
and 18.
May it please, your lordship. Your lordship, my senior is on his way, your lordship.
On?
On his way, your lordship. She went for.
Senior is on the way. Next second.
Item 19.
May I please, my lord? My lord, I'm praying for adjournment of this matter. My senior Mr. S.P. Chaudhary is having some difficulty, that's why he cannot come.
Is?
Certain personal difficulty, that is why he cannot come.
Acha. Your good name?
K. Vishwakarma, my lord.
Heard Mr. A. Vishwakarma, learned counsel. No, Mr. Vishwakarma, learned counsel appearing on behalf of Mr.
S.P. Chaudhary.
S.P. Chaudhary, learned arguing counsel for the appellant. Praise for listening the matter. After 1 week?
Yes, lordship. Can it be on Tuesday, lordship?
Next Tuesday, not possible.
Any date, lordship, if possible?
Last week of August.
On 29 or 8.
29 of August. However, none appears for the respondent not call. In the event of subsequent non-representation of the respondents, appropriate order shall follow.
Item 20.
I oblige.
Meet resource. So this is an appeal filed by Union of India Lordship out of an Manish suit Lordship, which has been disposed of by judgment and order dated 2019 in Manish suit number 34/2014 by the Civil Court of Silchar Lordship, Kasar.
You are for the appellant.
I am for the appellant Lordship.
Who is for the respondent?
In the costly, perhaps the L.R. Mazumdar name has been shown.
Eller Mazumdar. Eller Mazumdar, today he is not present, but one of his name is there.
Yes, I was not being informed that he is going to take time or something like that.
Pardon?
I am not being informed earlier, that there is some difficulty or something. I was waiting the whole day.
Third, Mr.
CKS Borua Lordship.
CKS Borua. Full name?
Chinmoy Kumar Sharma Borua.
Acha. Mr. Chinmoy Kumar Sharma Borua, learned counsel for the appellant. None appears for the respondent, though the name of Mr. Eller Mazumdar is reflected in the cause list. When to be listed?
Anytime, I am ready with the matter as per Lordship convenience.
22nd August.
22nd.
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 Not a problem.
You please inform Mr. Mazumdar if you.
I'll telephone in Lordship. Mass obligation.
Matter number 22, further matter.
Can you let me ask petition there? Criminal license number? Number is written as
And para 11 also, my lord. Personally, kindly see the para 11.
Paragraph number 15.
My lord, Rajasthan High Court judgment, my lord. It page 6 will be and para 11.
Yes.
My lord, the coordinate bench of this court at Principal Seat Jodhpur, criminal appeal number so and so, my lord. Thereafter, my lord, 12. In Arvind Mohan Sinha versus Amulya Kumar Biswas, 1974, 4 SC. It is referred, my lord.
No, that is there, but whether it can be extended in case of the SARS under section 307 IPC or not?
My lord, this is a case, my lord, where my lord charge was my lord 307, my lord.
Pardon?
My lord, this Rajasthan High Court is convicted under section 307.
No, Rajasthan High Court. They have simply referred to the decision of the Supreme Court, but whether that decision of Supreme Court relates to the SARS under section 307 IPC or not?
This was the case of my lord 307, my lord.
Which one?
Rajasthan High Court.
No. I am asking you about the decision of the Supreme Court.
Yes, my lord. That was like the Probation of Offender Act is a reformative measure, man. My lord, meaning
That is the principle. There is no quarrel.
Yes, ma'am.
In respect of the principle, it is applicable. But
my
whether it is applicable in 307 cases or not?
My lord, indirectly applicable, my lord.
Pardon?
Because this was, my lord, conviction under 307, my lord. That
Which
was-
one?
that is
Rajasthan
why
High
it was
Court?
referred, yes.
No, I am not referring to Rajasthan High Court decision. Whether the decision of the Supreme Court is where this observation was made, was in a surge under section 307 or not?
My lord, directly not.
Directly not.
Found, my lord. But what I understood, my lord, is the discretion of the court.
Which one? No, no.
This probation act, my lord, whether it
You
will be applicable or not. my lord.
going by section 30, oh no, sorry, going by section 4 of the Provision of the Offenders Act, can it be said that it can be extended to
307.
section 307?
It is, I have not found.
Directly, you have not.
But
That was the question I am asking you since long.
Lordship. My lord, I would like to refer, my lord, last to one judgment of the Supreme Court, my lord, which was reported in, my lord, 2019 criminal, LJ 397, my lord. My lord, this is a case, my lord, where, my lord, session judge, my lord, acquitted, there was a charge under section 307 and other section, my lord. And thereafter, my lord, state appeal, my lord. And the Honorable High Court, my lord, convicted the accused person under section 307 and other section, my lord. Then, my lord, it was traveled to the Honorable Supreme Court, my lord. Supreme Court, my lord, after going through the, my lord, judgment of the High Court, though it was not interfered, my lord. But, my lord, this sentence was, my lord, reduced to undergone, my lord, and the part of the compensation was increased, my lord. So, my lord, if I am in merit,
So Supreme Court has modified the sentence, whether the benefit of section 4 is extended to the appellants.
not mentioned, but
Not
my lord,
mentioned. If
so
it
far,
is
my
not
lord,
mentioned,
regarding-
then we have to presume.
regarding the, my lord, My lord, first, it's a offense of first offense and other things, my lord, it was delayed. And, my lord,
What to do? You produce one judgment of any judgment of Supreme Court where this provision of section 4, benefit of the provision of section 4 of the Provision of Offenders Act is extended.
Allahabad High Court also.
When
my
the
lord,
charge is framed under section
my lord,
307
I found
IPC.
the Allahabad High Court judgment on.
Allahabad High Court, no.
They had mentioned some Supreme Court judgment, my lord.
You see, if there is any reference to any judgment of Supreme Court there, if it is there, then you produce that judgment.
But so far, this
Oh.
judgment is, my lord.
We are giving you last opportunity. Heard in part, Mr. G. Uddin, Learned Counsel for the appellant, and Mr. P.S. Lawkor, Learned Additional PP for the state respondent, and Mr. M.A. Ahmed, A.C. Ahmed, Learned Counsel for the respondent number 2. Place the matter on. When? Speak now, judgment to produce.
On 13th, Tuesday.
Possible, Tuesday?
Possible, my lord, I have charged.
So no adjournment will be granted.
No, my lord, last if I not found, my lord, this Supreme Court judgment may consider, my lord.
Timing item 17 and 18.
Hmm.
And this is an appeal under section 18384 of Indian Succession Act against the granting of succession certificate in respect of the second wife, my lord, the
Succession certificate.
succession certificate in respect of the second wife. I am the first wife of the first wife of late Harkanta Datta, and he was serving under public health engineering department.
So what is the law?
Law, my lord, without making any party melody here in this case, my lord, the succession certificate was obtained by the second
Or
wife.
you have not been made a party to
Not-
the
not made
succession
party.
certificate, or no, to the application?
Yes, my lord. The order, your lordship may kindly see the order. I have annexed the application and order of the succession.
For my senior
Yes,
starts, may I just clarify? In 17, the petitioner challenges my succession certificate. In 18, I challenge the succession certificate granted to the petitioner.
I will submit it first, my lord. I will submit on the revision application also. The respondent has filed one revision application against my, against granting of my succession certificate in favor of me. This was filed, my case was filed at Nalbari because originally Harkanta Datta resided at Nalbari and I was his wife, and his property situated at Nalbari, and he was serving my lord at Difu. And there he married second wife filed an application before for granting a succession certificate at Difu, my lord. This is the case, my lord. The revision application doesn't lie, my lord. I will show the Supreme Court judgment, my lord, regarding this, where the appeal, provision of appeal is there, no revision lies, my lord. So I will submit on that, my lord. First, I am submitting on my appeal. Your lordship will find the order at page 9 of my appeal, ma'am.
Yes.
The order dated 2/3/2012, my lord. CR is put up today. Petitioner is present. General notices issued earlier are returned after service and without any objection. Hence, succession certificate be granted to the petitioner as paid for. The petitioner also submitted succession certificate, court fee stamped by realizing an amount of rupees 10,400 as the tax to the government, which is issued and signed. this was the order. Melody, the amount of succession certificate, these are regarding retirement dues, Melody. GIS for 4,560, leave salary 1,04,454, DCRG 1,23,970. As per pension rules, Melody, the first wife is entitled to, your lordship aware of that, Melody. The rule pension, as per pension rules 136, Melody, only the first wife is entitled to the pension, Melody, and other retirement benefit too. Your lordship may kindly see the page 6, Melody. Page 6 is the application submitted by the respondent, my lord, for granting succession certificate. Here, I
Page
was
number
not-
6.
Page 6, my lord. I was not made party, my lord, in this case, my lord. That is, I am showing my.
Yes.
The petitioner Srimati Rupali Barglari Datta, our statement is that the humble petitioner is the only wife of late Harkanta Datta, who was employee under administrative control of Executive Engineer PH3, Difu Rural Water Supply Division, Difu. That late Harkanta Datta, husband of the humble petitioner, expired on 14/10/2011, leaving the humble petitioner as his wife. That there is no any other near relatives of the deceased late Harkanta Datta except the petitioner. This was the statement. Late that the ordinary place of residence of the deceased at the time of his death was at village Difu, near ITI, PO and PS Difu, district Karbi Anglong, Assam, within the jurisdiction of your honorable court. There is no any nominee, will mortgage, etc. No nominee will mortgage, etc. against the name of the petitioner and family. Well, I am the first wife, it was suppressed. My maintenance case, there was an order in respect of my maintenance case, and that order was very much present in the executive engineer's office. And in that respect, the order was that the maintenance be deducted from the salary, and accordingly, I was getting maintenance from the salary. And it was.
Have you enclosed any order of that case?
Maintenance case,
Yes.
I have not annexed here,
So, what document you have with you to substantiate that you are the first wife?
In succession certificate, revision application, your lordship will find, succession certificate granted by the
At page number?
district judge Nalwari, at page number, 35 of the revision application.
Yes.
Pratima Datta versus Srimati Nivedita Datta, etc. I'm reading the judgment, The petitioner, paragraph 2, the petitioner Srimati Pratima Datta stated in her petition that her husband Harkanta Datta hereinafter for short deceased died intestate on 14/10/2011, leaving behind the petitioner and the OP number 1 and 2 as is legal here. OP number 1 is the married daughter of the petitioner and OP number 2 is the son of the petitioner. The petitioner states that the deceased made no will, etc. in regard to the properties mentioned in the schedule of the petition, and there is no impediment for the grant of succession certificate in favor of the petitioner being the wife of the deceased. Notice was issued upon OP number 1 and 2, and the same was duly served upon him. In spite of notice having been served upon them, they did not appear before the court, and hence the case proceeded ex parte against them. OP number 3, 4, and 5 filed petition, petition number 228, stating that they are also the sons of deceased Harkanta Datta. They stated that their mother Moni Datta is the second wife of the deceased. Within the wedlock between the deceased and said Moni Datta, the opposite party number 35 were born. Opposite party number 35 made prayer for impleading them in the case. Upon hearing the parties, this court impleaded them as opposite party number 3, 4, and 5. The contesting impleaded opposite party number 3, 3, 5 file written objection wherein it is averred that deceased married their mother, Moni Datta, who already died. Within the wedlock between the deceased Harkanto Datta and late Moni Datta, Sri Suman Datta, Sri Sanjay Datta and Sinku Datta, the oppositor party number 3, 4 and 5 were born. They state that the petitioner Putima Datta entered into marriage with the deceased in Palikuria Basudev Mandir, Nalbari, without performing marriage ceremony.
So,
and
Mr. Soduri, there is a finding of the court that you were the first wife of
first
the
wife.
deceased.
Yes.
Acha.
Court observed, my lord, I was the first wife, my lord.
Okay.
So, my lord, without.
So you saw the ruling of the Supreme Court where it is stated that only the first wife is
Yes.
entitled to.
Yeah, the reason application, my lord, doesn't lie, my lord. And first wife, regarding first wife entitlement, my lord, it is statutory rule, Assam services pension rules, my lord.
It is with you now. Assam
I have
services,
brought this pension rules, my lord. 136 rule
136. Kabir,
pension rules, my lord.
Assam pension rule is available here.
That is the definition of wife and entitlement. I'll find it now.
Perhaps one division bench judgment is there
Yes, my
of
lord.
this court.
So many judgments are there, my lord. Even Supreme Court, my lord. The first wife is the, as per statutory provision, her entitlement is there regarding pension and pension.
And the Supreme Court judgment.
Supreme Court judgment regarding maintainability of the revision application, my lord.
Acha, not on this point.
No, not on this point.
Okay. So your pair in this petition is for cancellation of the
Succession certificate.
succession certificate.
Order granting the succession certificate should be set aside, my lord. Regarding revision also, my lord, I am submitting.
No, revision he has preferred.
Yeah, my lord, since both are tagged together, my lord, regarding maintainability, I am just referring one paragraph of the judgment of the apex court, my lord. This is reported in, my lord, I am referring the 2000 legal Supreme Court 86. It was reported in SCC also, 2003, 3 SCC 524.
3 SCC
524.
524. This citation of this year.
2003, my lord, volume 3.
Yes.
Paragraph 6 says, my lord, in paragraph 6, my lord, I have given a copy of the judgment.
Yes.
The right of appeal is statutory right, and where the law provides remedy by filing an appeal on limited grounds, the grounds of salience cannot be enlarged by filing a petition under 226 and 227 of the Constitution on the premise that it is regarding MSCT case, my lord. The insurer has limited grounds available for challenging the award given by the tribunal. Section 149(2) of this act limits the insurer to file an appeal on those enumerated grounds, and the appeal being a product of the statute, it is not open to an insurer to take any plea other than those provided under Section 149(2) of the act. See National Insurance Company Limited, Chandigarh versus Nicoletta Rohtagi and others, 2002-7 SCC 456.
This being the legal position, the petition filed under 227 of the Constitution by the insurer was wholly misconceived. Where a statutory right to file an appeal has been provided for, it is not open to the High Court to entertain a petition under Article 227 of the Constitution. Even if where a remedy by way of an appeal has not been provided for against the order of and judgment of a district judge, the remedy available to the aggrieved person is to file revision before the High Court under Section 115 of the Code of Civil Procedure, where remedy for filing a revision before the High Court and under Section 115 CPC has been expressly barred by a state enactment. Only in such case, a petition under Article 227 of the Constitution would lie, and not under Article 226 of the Constitution. As a matter of an illustration, where a trial court in a civil suit refused to grant temporary injunction and an appeal against refusal to grant injunction has been rejected, and a state enactment has barred the remedy of filing revision of under Section 115 CPC. In such situation, a writ petition under 227 would lie and not under 226 of the Constitution. Thus, where the state legislature has barred the remedy of filing revision petition before the High Court under Section 115 CPC, no petition under 226 of the Constitution would lie, for the reason that mere a wrong decision without anything more is not enough to attract jurisdiction of High Court 226. Subsequent to that also, my lord, there are so many decisions, my lord, where there is remedy of appeal that cannot be overridden by filing a revision application. My lord. This is my humble submission.
Lordship, in my petition, the petitioner is questioning the maintainability. However, no pleadings have been filed. This petition has not been objected to. Therefore, I am taken by surprise by this point, because there is no pleadings and no objections have been filed against this revision application. So if some point has to be taken, firstly, I have to give an opportunity to rebut. Lordship. No objection, no pleadings have been filed objecting my revision application.
No, he has raised the question of maintainability.
Lordship, but pleadings is not filed, Lordship. There is no objection in this regard to my pleading, firstly. Secondly, Lordship, so without filing an objection or pleadings, that my chance to give a reply would come if this objection was taken in pleading. No pleading has been filed. So this revision application has not been objected to by the petitioner. But
it's a legal question, my lord, regarding jurisdiction, my lord.
But still, Lordship,
What objection is required, my lord? There is no rules, my lord, for filing objection, my lord.
Lordship, I have already stated in my pleading why I have opted for this remedy. If Lordship sees my revision application, it's under 227 read with 115 and 384 of the Indian Succession Act. Therefore, Lordship, in 12.5, Lordship, paragraph 12.5, I have already stated why I have opted for this remedy. Now, if there was any objection from I could have filed a reply, but there was no pleadings objecting this, firstly. Secondly, in my petition, his succession certificate has been challenged on the ground that when he obtained, I'll show the documents. I have all the documents. When I was the one, Lordship will take my application.
No, one by one. First, let us complete this appeal.
Actually, no objection is filed against my appeal. Therefore, whatever objections is raised, Lordship,
No, the appeal preferred by him.
Yes.
So admittedly, she was not made a party.
I was the
before the deputy commissioner.
I was the first one who applied. Now, if Lordship, I was showing page 14 of my petition. Page 14 of my petition, item number 18. I did not knew about her, but she knew about me, but still in her succession order, I was not made a party. Even the children of the second wife was not made a party. If your lordship sees the succession order, it is given to the wives and the children. Now the children are not made party to this petition, testimonial appeal. Then how it is maintainable? It is non-joiner of necessary parties. Now your lordship would see page 14 for a moment. It is dated page 13. Lordship would see the date for us. It is by the Office of the Executive Engineer, Diffu Rural WS Division, 15/7/2012. As per your letter date, so and so, I herewith you will require information for your necessary action. She asked, Lordship would see column 8 at page 14. In addition to this applicant, if any other person has take claim to receive the amount stated above, then the name and address of the person. Srimati Rupali Baglari Datta has take claim since she got married to late Horikanta Datta as per information given. So before filing the succession case, she filed this application before the authorities. Authority says that another Rupali Baglari, that is me, it is who is taking the claim. But still, she did not make a party in her succession order before the district judge. Now, secondly, Lordship was asking about the law by which succession certificates are granted and who is the jurisdictional authority to grant a succession certificate. Now, your Lordship would see the section 370 of the Succession, Indian Succession Act 1925. 370-71. That
Yes.
371. The district judge within whose jurisdiction the deceased ordinarily resided at the time of his death, or if at that time he has no fixed place of residence, the district judge within whose jurisdiction any part of the property of the deceased may be found may grant a certificate under this part. Now I fall in the first part. I had a fixed place. I was working at Diffu. I died at Diffu. I have annexed all the deposition of all the that I stayed in Diffu and I died in Diffu. But suppose for the, let us presume that the first part is not applicable.
No. District judge of the concerned place has the jurisdiction.
Jurisdiction.
Yes.
So
then in some cases, High Court empowered the Munsif also in granting the succession certificates.
But as per 371, the district judge within which jurisdiction the deceased ordinarily resided or the property can be found is the jurisdictional magistrate, the district judge who is empowered to grant the succession certificate. That's the law. Now, Lordship would see what is the property at page 52. The property is the property is the Lordship would see it's the amount payable. It's a succession certificate of the respondents. The amount is payable to the deceased Horikanta Datta as monthly. That is the office, Diffu division rural. Therefore, the amount is payable next is same thing, Lordship, every property is from the office of Diffu, Lordship. I will show at page 47, 43, 48 that this is resided in Diffu, died in Diffu, and the property also lies in Diffu. So now the succession certificate of the respondents has been granted by District Judge Nalbari, who is not jurisdictionally empowered to grant as per 371. That is my first submission. Secondly, Lordship, Lordship would come to the order at page 35. That is the judgment of the District Judge Nalbari.
Page number?
Page 35. Lordship would see the array of parties: Pratibha Datta, Nivedita Datta, Nitu Datta, Sanjoy Datta, Sintu Datta, and Suman Datta is the respondents. Means the deceased has 3 wives. First is Pratibha Datta, second is Mani Datta, and third is Rupali Baglari Datta. So the array of parties in the column of the respondents, opposite parties, is the sons and daughters of the second wife. Now, your
No,
lordship,
here the petitioner Pratima Datta is the second wife.
first wife is Pratima Datta.
Huh.
Second wife is Mani Datta, who has died. Now, these Nivedita Datta, Nitu Datta, Sanjoy Datta, Sintu Datta, and Suman Datta are children of the second wife. Now, Lordship would kindly note 2 things here. Lordship, I have already read out 2012 letter where the authority said that I have staked a claim on her application. But Lordship would see that I am not made a party, firstly. Lordship would get it at page 14. Secondly, Lordship would see that these are the parties who were the respondents in the succession judgment. Now, Lordship would come to the operative part of the judgment. Issue number 1. Petitioner issue number, Lordship, 2 is relevant. PW1 denied the deceased wife Mani Datta. It is also denied that OP number 3 and
Which
5
paragraph? Which paragraph you were reading?
page 39, para 16, issue number 2.
Yes.
petitioner denied the deceased married Moni Datta, it is also denied the opposite party 3 and 5 were born within the wedlock between deceased and Moni Datta. Opposite 3 and 5 in their written statement categorically stated that Harikanta Datta, the deceased, married their mother Moni Datta within the wedlock they were born. The mother Moni Datta already expired. In support of his claim, to one of the deceased 3 and 5 adduced evidence of 3 DW1. Sri Raman Datta is the brother of the deceased. He deposed that in the year 1985 he got married, and in the same year deceased also married Moni Datta as a second wife at Bukajan in the district of Karbi Anglong. He deposed that within the wedlock between the deceased and Moni Datta, Sanjoy Datta, Sumon Datta, Sintu Datta, opposite party, Sintu Datta, the opposite party, 3 to 5 were born in 1995. Moni Datta died at Bukajan. DW2, who is the wife of DW, supported the evidence of DW1. Two things comes out that the respondents are children of Moni Datta, and secondly, the deceased died in Bukajan. Therefore, it was the district. It was not district judge Nalbari who was empowered to pass an order or issue a succession certificate. Now, Lordship would see page 40, issue number 3 and 4.
No, the question is whether the deceased resides at Nalbari or not at any point of time.
No, at that time, Lordship, I'll read it again, Lordship, 371. I'll come to 371, Lordship. Let me read issue number 3 and 4. Just one paragraph. Page 40, issue 3 and 4. In view of the findings arrived in the ongoing issues, I find that the petitioner being the wife of the deceased and the opposite party number 3 to 5 being the son of the deceased through second marriage are entitled to get the succession of their respective share. All 5 children, opposite party 1 to 5 of the deceased and his wife, the petitioner Srimati Prabha Datta, shall be entitled to 1/6 of the share of the amount 3,51,000 791. As mentioned in the schedule of the petition, the petitioner shall be entitled to 3/6 share of the amount mentioned in the schedule of the petition for herself and her children. OP1, OP2, OP3 to 5 shall be entitled to 3/6 of the share the amount mentioned in the schedule. Therefore, let succession certificate be issued according in favor of petition number OP3 to 5 as per their entitlement as discussed above on payment or requisite court fee. It had to fee and on furnishing required indemnity bond undertaking to satisfy any claim in respect of the debts and securities involved in the succession certificate. The case stands disposed of. Now the succession property is in default firstly, and secondly, all the OPs were given their share. It is more important that they should be made a party in this proceedings, Lordship. They have a share in the succession certificates, Lordship, but they are not made parties in the testamentary appeal. Lordship, this is bad for non-jointer of necessary parties, Lordship. That is my second.
I am not challenging their share, my lord. So they have not been made party. Only, and in this case, I am not filing any appeal. I am challenging the appeal of the petition filed by him where the succession certificate was granted. I was not made party. Why should I make them party here in this appeal, my lord? Only I want, my lord, that this should be set aside and a proper adjudication should be made either at Diffu or Nalbari, my lord. And a jurisdictional point already I have submitted, my lord, that a revision application, if your lordship hear the matter, my lord, first your lordship will confer jurisdiction. Whether a revision application will lie in respect of the.
Okay, Mr. Sudhir, let him complete. Director,
Yes.
yes.
Now, firstly, Lordship would see that in this appeal, I should be made a party because the petitioner was let known that I was there, but intentionally I was not made a party. And in this petition, the shareholders of the succession certificate should have been made a party. Now they are also not there. Lordship, this petition cannot be decided without them. Because any decision in this point will affect them. Because already I have made out a prima facie case on the first day, and this succession certificate and the order has been stayed, Lordship. Now, suppose tomorrow Lordship sets aside this order, they will also lose their share. Now, therefore, these children of Moni Datta was a necessary.
No, you are not their counsel now. Are you?
No, but I am legal lacuna. I am just pointing it out.
No, the question is, Mr. Sururi has raised the question that this regarding this maintainability of this revision petition.
Yes, Lord.
You answered that point.
Firstly, I have already shown that it is without jurisdiction. Secondly,
no, the question is whether it is maintainable.
No, I am coming to that. Secondly, I have shown that it is in violation. I was not a party. It is violation of my natural justice. I would submit that these are the two exceptions to the bar of alternative remedy. Ultimately, High Court is not barred from entertaining a writ petition if there is a statutory appeal provision. Lordship, and Lordship would kindly see, Lordship.
No, Mr. Soduri has already referred one judgment of the Supreme Court.
Lordship,
Sadhana Lord.
If Lordship allows me, because you see, in this, Lordship would see that in this petition, no objections have been filed. So I have been, for the first time, I have come. If I would have known that
this. He may not file objection.
Sorry, Lordship.
He may not file objection.
But there are also judgments where it is that.
No, why he cannot raise the issue of jurisdiction?
Yes, but the thing is that there are also judgments that if an order is passed without jurisdiction and without the principle of natural justice, then alternative remedy is not a bar. There are judgments. So if I could have known that this point would have been raised, Lordship, I could have brought the judgments. There are many judgments to that effect.
Okay, you produce those judgments then. Let us fix
Lordship.
it on tomorrow or day after. Wait,
On
Can it-
Tuesday, my lord. Tomorrow.
Tuesday.
Tuesday.
You produce the judgment.
Yes. I will also bring some judgment. my lord.
Okay.
Latest judgment.
I will make my submission once again, that if an order is passed without jurisdiction and in violation of natural justice, alternative remedy is not a bar.
Mr. Bora, going by the definition of this section 371, can it be said that the district judge Nalbari has no jurisdiction and at no point of time the disease resided at Nalbari?
No, Lordship, I'll read it again. The district judge within whose jurisdiction the deceased ordinarily resided at the time of his death. Now I will show the depositions of all I have annexed the depositions. I will show that ordinarily also he resided in Diffu and at the time of his death, he resided in Diffu. I have annexed all. On the next date, I will show this. Then secondly, Lordship would see,
yes, whether he has any property at Nalbari.
Yes.
No, these succession certificates relates to only these properties mentioned in the succession certificate. This succession certificate does not relate to any other things. That's why I was pointing out at page 52. That's why I was pointing out at page 52, which are the properties involved in these succession certificates. Sometimes even succession certificate in the MBI is needed for a car, transfer of a car.
So that succession certificate only belongs to that car. So this property, all the properties involved in this succession certificate is in default. Therefore, we are only concerned with this succession certificate. I qualify the first point. I will show it the deposition.
No, they
also.
say any part of the property of the deceased. Whether it relates to only those properties in respect of which succession certificate was sought for.
But this succession certificate is under challenge, Lordship. Now, this succession certificate only covers the payables from the default office. That's all. And there is no statement in the pleadings that says that any part of the property of the deceased was in Nalbari. So I qualify the first point only. I ordinarily resided in Diffu, and at the time of the death, I was in Diffu. So,
Agreed, but at no point of time you reside at Nalbari.
Nalbari, Lordship, I have not made any. I have to seek instructions
No,
on
no, you answer my question.
So, regarding residing at Nalbari, I have to take specific instruction firstly. Secondly, suppose I might have been born in Nalbari, suppose. But that is not the criteria to qualify the jurisdictional clause. To qualify the jurisdictional clause, I have to ordinarily reside in Lordship, the ordinarily resided. I ordinarily resided at the time in Diffu. At the time of the death also, I resided in Diffu. All the even the depositions of all the persons, I will read it out on the next date, which says that I resided in Diffu, I died in Diffu. Therefore, I qualify the first clause only. I qualify both the clauses because the succession certificate relates to the Diffu properties of the Diffu office. Therefore, so only the jurisdictional authority at Diffu is the empowered authority to issue succession certificate in my case. In case of Horikant Doctor. That is my humble submission.
So in which office he was serving?
Executive Engineer, Diffu,
PWD.
Public Health, sorry.
Public Health Office headquarters is at Guwahati also.
Yes. No, at Lordship would kindly.
No.
Maybe, but at that, I always resided in Diffu. I died in Diffu. That is the clause, Lordship.
Okay. You produce the judgment, so you will see.
Yes.
Heard Mr. D. Chaudhary, learned senior counsel.
No.
Learned counsel for the appellant in RS in that testamentary appeal number 3 of 2022. And Mr. Bora, learned respondent. And in CRP, Mr. Bora, learned counsel for the petitioner, and Mr. Chaudhary for the respondent. Heard in part, please the matter on Tuesday.
Yes. Deeply obliged.
Adam, 16.
So do we start?
Yes, please.
Will be able to complete within this period? So whether any court previously heard this matter?
Yes, Lordship.
Who?
Court 10. Court 10, Honorable Justice S.K. Mehdi, sir.
SK Mehdi.
But it was not made part heard, Lordship.
This
Right, Lordship, in this case, suit was filed by us, Lordship, they filed counterclaim. Suit dismissed, counterclaim dismissed, Lordship. Then we preferred first appeal, they did not prefer any first appeal or cross appeal, Lordship. So counterclaim already not in the record, Lordship, it was already dismissed. Only against suit part, Lordship, they are fighting. And suit is for right title interest and confirmation of possession, Lordship, there is nothing to keep
suit
it
is
pending.
for
Right title interest and confirmation of possession. We are possessing the land, Lordship.
so how much time will you take? Could we complete it in half an hour?
Yes, Lordship, first appellate court judgment, if he reads, Lordship, your Lordship can take a decision.
What is the substantial question of law?
Order dated 4/6/2018, Lordship. 2017 matter, Lordship. Our prayer was is in page 8, Lordship.
Yes.
Page 8, Lordship. We are plaintiffs, Lordship, and our prayer was for decree of declaration that the
Page
plaintiffs have
8 of the judgment.
page 8 of the appeal memo, Lordship. That is plaint of the Lordship respondents. Plaintiff's claim is for decree of declaration that the plaintiffs have right title interest with confirmation of possession of the lands described in Schedule B as per Rayati Khatiyan. For a decree of declaration that the defendant number 6 has no legal authority to cancel the Rayati Khatiyan already issued in the name of the plaintiffs, and the defendant number 7 has no legal right to correct the land records of the suit land in the names of the defendant number 1 to 4 on the basis of illegal order of defendant number 6. For a decree of permanent injunction restraining the defendant number 1 to 4 their servants, agents, etc. from interfering and dispossessing the plaintiffs from the suit land. Your Lordship, if my learned friend reads the title appellate judgment, Lordship, that is page 34.
Let me read from paragraph number 5, Lordship. Page number 35.
Yes, so let us start.
Lordship, let me read the judgment of title appeal, Lordship, at page number 34. Let me start with paragraph number 5 at page number 35, Lordship.
Paragraph number
5
5.
at page number 35, Lordship.
Yes.
The plaintiff appellant plaintiffs are the respondent challenge, Lordship. The plaintiff's appellants have instituted a suit against the defendants alleging therein that a plot of land measuring about 7 bighas 1 kotha covered by Miadipatta number so and so of Tausi number so and so of Tag number 196 situated at village Mankasar was originally owned by one Farid Sarkar, and after his death the aforesaid land was inherited by his son Abdul Ghani Sarkar, that is the predecessor of the pro forma defendants pro forma respondents. The plaintiff had pleaded that the Abdul Ghani Sarkar during his lifetime settled a plot of land measuring 10 kathas according to Karyabari measurement in favor of the plaintiff number 1 Sri Abdul Sahid as tenant and delivered the possession of the same in Bengali year 1362. According to the plaintiffs, Abdul Ghani Sarkar died sometimes during the year 1973. The plaintiffs had pleaded that the plaintiff number 1 become the permanent tenant under the landlord Abdul Ghani Sarkar under the Assam Temporarily Settled Areas Tenancy Act 1971 and obtained writing title in his name. According to the plaintiffs, the plaintiff number 1 transferred a plot of land measuring 12 places to the plaintiff number 2, Sri Noor Abedin, and transferred another plot of land measuring 16 places to predecessor of plaintiff number 3, Majibur Rahman, and thus a plot of land measuring about 3 kathas, 4 places remained under the occupation of plaintiff number 1, and that all the plaintiffs constructed their residential houses in their respective plots of land and started to reside there. The plaintiff have described this plot of land which remain in their possession in Schedule B of the plaint and thereafter and hereinafter referred to as the suit land. The plaintiff had alleged that the defendant number 2, Sri Hamidul Islam, filed a petition on 8/12/2002 before the settlement officer, that is defendant number 6, and got the rioting items cancelled which stood in the name of plaintiffs and got the names of the defendant number 1 to 4, that is respondent number 1 to 4, recorded therein in Miss Case number 14 of 2004, and on the basis of the aforesaid illegal mutation, they are claiming the land belonging to plaintiffs and are trying to evict the plaintiffs. Hence, this suit praying for declaration of right, title, and interest of the plaintiffs about the suit land, and also for correction of the revenue records in the names of the plaintiffs by cancelling the mutation in favor of the defendant number 1 to 4. The defendant number 1 to 4 filed their showing written statements along with a counterclaim stating therein that the suit is not maintainable. The above named defendant contended that the plaintiffs were never allotted or settled with the suit land by Abdul Ghani Sarkar as alleged by the plaintiff, and that the plaintiffs are not the riots, as such they do not have any permanent and heritable right over the same. The defendants had pleaded that Farid Sarkar, the original owner, had land measuring 13 bighas, 14 kathas, 17 foot under the AE Tausi number 330, of which the eastern part got submerged in river Kalu and the western part was sent, which was recorded in tag number 196 under item number 251. According to the defendants, the plaintiffs illegally occupied the southwest part of the above land and illegally claimed to be the tenants and got their names recorded as riots illegally. As such, the defendant applied for cancellation of the same and got the names of the plaintiffs cancelled by order passed in miscase number 14 of 2004. The defendant had further contended that the aforesaid land was originally possessed by two tenants, Nazimuddin and Kasimuddin, but they defaulted in the payment of rent, and as such, the same was sold in auction in case number so and so. The defendants further contended that they inherited land measuring 7 bighas, 1 kotha under DAG number 196 of item number 251 from Farid Sarkar, but the plaintiffs took possession of 4 kotha 10 lesas of land when the land emerged from river bed. The defendant further alleged that the plaintiffs took shelter over the Schedule B land sometimes during the year 1988 at the time of floods by constructing temporary sheds, but later on in the year 1989 illegally got their names recorded as riots in the settlement operation. The defendants had contended that they come to know about the mutation of the names of the plaintiffs as riots over the suit land in the year 1995, hence they applied for cancellation of the name and got it cancelled in miscase number so and so. The defendants has contended that the plaintiffs are the permissive occupiers in respect of the suit land, as such prayed for eviction of the plaintiffs. The plaintiffs filed their written statements against the counterclaim and stated therein that the counterclaim is not maintainable. The plaintiffs further contended that the defendant number 1 to 4 are not the linear descendants of Farid Sarkar, who was a citizen of East Pakistan. As such, they do not have any right to inherit the suit land. The plaintiffs further contended that the suit land was settled by Abdul Ghani Sarkar and they acquired the right of a permanent tenant and were residing thereon by constructing their residential houses. As such, prayed for dismissal of the counterclaim. The plaintiff further denied that they were permissive occupiers in respect of the suit land. Upon hearing, the trial court from the following issues. From paragraph number 9, Lordship, during trial, both the parties laid evidence in support of their case. After hearing both sides, the learned trial court by the impugned judgment dated so and so dismissed the suit as well as the counterclaim. It would be pertinent to mention herein that the defendants did not file any cross appeal or cross objection against the dismissal of their counterclaim. On being aggrieved by and dissatisfied with the impugned judgment, the plaintiff appellants prefer the present appeal, amongst other on the following grounds. The discussion one. Points for determination. Whether the learned trial court had rightly decided issue number 1, 6 and 7, wherein it is held that the plaintiffs have failed to prove their right, title and interest over the suit land, and also held that the defendants are not entitled to recover first possession of the suit land. Paragraph number 14, from paragraph number 14, Lordship. I have perused the judgment and case records. The perusal of the impugned judgment reveals that the Leidner trial court had ignored the Pattanama, Exhibit 1, by which the plaintiff number 1 allegedly came into the possession of the suit land as a riot under Abdul Ghani Sarkar way back in the year 1956-57. Now, the under trial court had, in the impugned judgment, observed that the plaintiff's witness could not state as to when the aforesaid Exhibit 1 patta number was executed, and as such the learned trial court did not consider the said patta number. The learned trial court had also observed in the impugned judgment that the plaintiff have not averred that they had paid rent to the landlord. As such, the plea of tenancy of the plaintiffs was not believed by the learned trial court. Now let me discuss the entire material on record and try to arrive at independent findings. The plaintiff number 1, Sri Abdul Shahid, had deposed that Abdul Ghani Sarkar, who was the owner of the suit land, had settled the suit land in his favor by execution of the patta number marked as Exhibit 1. I have perused the Exhibit 1 and it appears that the executant, Sri Abdul Ghani Sarkar, had settled the suit land in favor of the plaintiff number 1, Sri Abdul Sahid, as a tenant upon payment of rent and had even fixed the yearly rent of the suit land. PW1 Sri Abdul Sahid had identified the aforesaid Pattanama and had stated in his cross-examination that the Pattanama was written by one Somesh Sarkar and was executed by Abdul Ghani Sarkar. It is an admitted fact that Abdul Ghani Sarkar is presently dead. The perusal of the Exhibit 1 reveals that the aforesaid Pattanama was executed on 27/13/62 Bengali year. The Bengali year of 1362 would correspond to English year 1956-57. As such, it is seen that the Exhibit 1 is a document which is more than 30 years old. Hence, the legal presumption under Section 90 of Evidence Act 1872 can very well be drawn, and it can be presumed that the aforesaid Exhibit 1 was properly and duly executed by the executant Sri Abdul Ghani Sarkar. The fact that the Exhibit 1 is a document which is more than 30 years old and is produced by plaintiff number 1, who is the person in whose favor the suit land was settled by the Exhibit 1, and it shows that the production of the above document is done from proper custody. In addition to above, it is an admitted fact that the Abdul Ghani Sarkar, the executant of the above document, is dead. As such, it is held that the plaintiff have properly proved the due execution of the Exhibit 1. The PW1 Sri Abdul Sahid had further produced the rent payment receipt marked as Exhibit 2 and Exhibit 3 to show that he paid the rent of the suit land to Abdul Ghani Sarkar. Perusal of Exhibit 2 reveals that the same pertains to Bengali year 1362, that is English year 1956-57. The PW1 was cross-examined in respect of the aforesaid document, and in his cross-examination, he had specifically stated that Exhibit 2, rent payment receipt, was written by Abdul Ghani Sarkar. There is nothing on record to doubt or disbelieve the above statement of PW1. In addition to above, the Exhibit 2 is also a document which is more than 30 years old and is produced from proper custody of PW1, Sri Abdul Sahid. The custody of the above document is held to be proper because the above rent was paid by Sri Abdul Sahid. As such, it is natural that the receipt would be with him. Considering the facts that the Exhibit 2 is a document which is 30 years old, is produced from proper custody, it is presumed that the same is executed by Abdul Ghani Sarkar after receipt of the rent for the suit land. The learned counsel for the respondent had contended that the Exhibit 2 does not contain signature of Abdul Ghani Sarkar. As such, same cannot be relied upon. The above contention of the respondent is not sustainable because PW1 had specifically stated that the Exhibit 2 was written by Abdul Ghani Sarkar, which means that he had executed the same after receipt of the rent, and merely because the signature of the Abdul Ghani Sarkar is not present, same would not make the Exhibit 2 inadmissible. It is seen from the above that the Abdul Ghani Sarkar had settled the above suit land in favor of the plaintiff number 1 upon execution of Exhibit 1, and further he had received the rent for the aforesaid suit land by execution of the Exhibit 2. As such, the finding of the learned trial court to the effect that the plaintiff have failed to aver and prove that they are the tenants under Abdul Ghani Sarkar is held to be erroneous and not based upon the materials on record. The contention of the plaintiffs that the suit land was settled in favor of the plaintiff number 1 by Abdul Ghani Sarkar as a tenant, and that they had acquired a right of permanent tenants after passing of Assam Temporary Settled Areas Tenancy Act 1971. Further finds support from the fact that righty khatians were admittedly issued in the names of the plaintiffs. The plaintiffs have also produced the righty khatians issued in their names in respect of the suit land, and the same are marked as Exhibit 4, 5, and 6. The righty khatians in the names of the plaintiffs are sufficient proof of the fact that the plaintiffs were the permanent tenant in respect of the suit land. The perusal of Exhibit 4, 5, and 6 reveals that the plaintiffs were in possession of the suit land for about 24 to 25 years since the date of issuance of the cartiers, which fully corroborates the fact that the plaintiffs were in possession of the suit land much prior to the issuance of the cartiers in their names as tenant under the original land rent. In addition to above, the presence of Exhibit 1 and Exhibit 2, which are the Pattanama and the rent payment receipts, further leads support to the fact that the righty cartiers, Exhibit 4, 5, and 6, were properly issued to the plaintiffs as they were tenants in respect of the suit land, and the plaintiffs are able to prove their source of title upon the suit land. The plaintiffs have proved that the plaintiff number 1 came into the possession of the suit land as tenant initially under the original landlord, and thereafter he inducted the plaintiff number 2 and Majibur Rahman, predecessor of plaintiff number 3, and had also paid the rent of the suit land, and as such, after passing of Assam Temporarily Settled Areas Tenancy Act, their names were recorded as permanent tenants in respect of the suit land. The perusal of the impugned judgment reveals that the learned trial court had observed that PW2 Sri Akhtar Hussain and PW3 Sri Basuruddin had stated in their cross-examination that they cannot say as to when the patta number was executed. As such, the learned trial court chose to ignore the Exhibit 1 and held that the contention of the plaintiffs that the plaintiff number 1 came into possession of the suit land as tenant cannot be believed. In my considered opinion, the learned trial court had erred in refusing to take into consideration the Exhibit 1 to Exhibit 6 because the above documents are sufficiently proved by plaintiffs, and the above documents clearly proves that the plaintiffs came into possession of the suit land as tenants under the original landlord and have continued in possession of the same. The learned trial court have further observed in the impugned judgment that the plaintiffs have failed to avoid and prove that they had paid the land rents to the suit land regularly. The facts as to whether the plaintiffs are defaulted in payment of rent of the suit land or not is not an issue in this suit. As such, plaintiffs are not required to prove the fact that they had regularly paid the rent, and merely because the plaintiffs have not produced or proved the payment of rents for subsequent periods, the same would not disentitle them from character of permanent tenant in respect of the suit land. The Assam Temporarily Settled Tenancy Act provides for specific procedure to be followed for eviction of tenant in case they are defaulters. As such, the landlord ought to have approached for eviction under the said procedure, but in the instant case at hand, there is no material that the plaintiffs were evicted at any point of time for being defaulted or that the landlords had brought any such action. In view of the above discussion, it is held that the fact as to whether the plaintiffs are defaulted in payment of rent or not, and as to whether they have subsequently paid their rent or not, is not material in the outcome of this case. And as such, no reliance could be placed upon the said fact, and consequently no inference can be drawn as regards the tenancy of the plaintiffs. It is also an admitted fact that the plaintiffs are in possession of the suit land by constructing the residential houses thereon, but the perusal of the impugned judgment reveals that the learned trial court had created an uncalled for controversy in this regard. The possession of the plaintiffs over the suit land is not at all disputed by any of the parties. In fact, the defendant number 1 to 4 had admitted that the plaintiffs are in possession of the suit land. However, the defendant number 1 to 4 contended that the plaintiffs are not tenants but permissive occupiers. The perusal of the impugned judgment reveals that the learned trial court had in page 6 of her judgment stated that the plaintiff's evidence reveals that suit land is recorded in defendants' names but possessed by plaintiffs. However, it is settled that mutation is the prima facie proof of possession. In that view of the matter, the possession of the suit land by the defendants only entitled them to have possessory right over the suit land. Plaintiff possession over the suit land is all the more doubtful as PW2 has categorically stated in cross-examination that plaintiff's number 1 house is situated at 1.5 furlong distance from the suit land. Consequently, it can be inferred that the plaintiffs have failed to probabilize their right, title, interest in possession over the suit B land, Schedule B land, and plaintiffs cannot derive any transferable right over the suit land. It is seen from the above that the learned trial court had ignored the evidence as regards the possession of the plaintiffs over the suit land and had also ignored the fact that none of the parties had disputed possession of the plaintiffs over the suit land. In fact, the defendant number 1 to 4 had filed counterclaim for eviction of plaintiffs from the suit land. As such, in face of proof, there is no room for prima facie opinions, and thus the observation of the learned trial court to the effect that the plaintiffs had failed to prove that they are in possession of the suit land is not based upon materials on record. Hence, it is held that the plaintiffs have proved that they are in possession of the suit land. The defendant number 1 to 4 have contended that the plaintiffs came into occupation of the suit land in the year 1988 during the floods, and the defendants permitted them to reside over the suit land. As such, let me now discuss as to whether the defendants could prove that the plaintiffs are permissive occupiers in respect of the suit land. The defendant side had examined only the defendant Sri Hamidul Islam in support of their case. The DW1 had deposed that the plaintiffs are the illegal occupants in respect of the suit land, and that the plaintiffs have encroached upon the same and made illegal construction. The DW1 had specifically stated in his examination in chief that one Nazaruddin and Kasimuddin were the tenants in respect of the suit lands, and that they went away after surrendering their tenancy as they defaulted in payment of the rent, white shell case number so and so, and since then the aforesaid suit land was vacant. In the same was not settled in favor of any other person. Hence, the plaintiffs are illegal occupants. The perusal of the above statement reveals that the sole witness for the defendants, namely DW1 Sri Hamidul Islam, had not supported the person of the defendants to the effect that the plaintiffs are permissive occupiers in respect of the suit land, and that the defendants had permitted them to stay over the suit land at the time of flood in the year 1988. In fact, the DW1 had claimed that the plaintiff had illegally encroached upon the suit land, which in itself belies the pleadings of defendants to the effect that the plaintiffs are permissive occupiers in respect of the suit land. The DW1 had not stated a single statement to the effect that the plaintiffs are permissive occupiers in respect of the suit land. The DW1 had also failed to state as to how, when, and who allowed the plaintiffs to stay over the suit land. As such, it is held that the defendants had failed to prove that the plaintiffs are permissive occupiers in respect of the suit land. On the contrary, the plaintiffs have, as already discussed above, sufficiently proved that they are the permanent tenants in respect of the suit land, and that they are in possession over the suit land since long, that they had occupied the suit land as riots under the original land rights. The defendant had produced one power of attorney, Exhibit A, purportedly executed by Abdul Ghani Sarkar in favor of the predecessor of the defendants, namely Sri Syed Rahman, to stake claim upon the suit land. I have perused Exhibit A, and it appears that Sri Abdul Ghani Sarkar authorized Sri Syed Rahman take care of his landed property and to collect rent and to do other things in that regard. But the perusal of Exhibit A does not reveal that Abdul Ghani Sarkar had transferred or sold his right over the suit land in favor of Sri Syed Rahman. As such, defendant number 1 to 4, or for that matter, the Sri Syed Rahman, cannot claim any right, title, or interest over the suit land. The power of attorney is not a document of title. As such, the same cannot effect any transfer in respect of the suit land, but it merely authorized Sri Syed Rahman to deal with the suit land and along with other properties of Abdul Ghani Sarkar. The defendant number 1 to 4 have failed to produce any documents of title in their favor to show that they had acquired any right, title, and interest over the suit land. As such, it is held that the defendant number 124 does not have any right, title, and interest over the suit land. It is admitted fact that the names of the defendant number 124 was mutated in respect of the suit land by cancelling the names of the plaintiffs from the revenue records in mesh case number so and so. I have already discussed above that the defendants number 124 have failed to prove their right, title, and interest over the suit land. As such, the mutation of their names in respect of the suit land by cancelling names of the plaintiffs as riots is illegal and liable to be declared as such. Moreover, it is already held that the plaintiffs are permanent tenants in respect of the suit land and that Farid Sarkar, or for that matter, his son Abdul Ghani Sarkar, are landlords. As such, even if it is held that the defendants have derived in it right, title, and interest over the suit land through Farid Sarkar or Abdul Ghani Sarkar, then also they would step in the shoes of Farid Sarkar or Abdul Ghani Sarkar and would assume the character of landlord, but the right, title, or interest of the plaintiffs of the suit land as permanent tenants or riots cannot be extinguished. Hence, it is held that the cancellation of the names of the plaintiffs as riots in respect of the suit land in mesh case number so and so is illegal. In view of above discussion, the decision of learned trial court in issue number so and so are set aside, and it is held that plaintiffs have put right, title, and interest and possession over the schedule B land as permanent tenants riots, and that they are not permissive occupiers under defendants, and hence they are not liable to be affected from the schedule B. This is
Finding of the appellate court.
I order it at page number 50 in view of above discussion, paragraph number 34. In view of above discussion, the impugned judgment and decree dated so and so passed by London Munship number 2 Superior Service set aside. It is held that the plaintiffs have right, title, interest, possession over the schedule B land. It is further held that the cancellation of the names of plaintiffs by order in mesh case number so and so is illegal and liable to be set aside. The revenue records be corrected. It is further held that defendant number 124 are not entitled to any reliefs and consequently their counterclaims then dismissed. Substantial questions suggested in the appeal at page number 4 of the appeal memo. The patta number and the revenue paying receipt. It was
So the Khatian was cancelled by the revenue authority.
revenue authority. Dependent number 6, that is settlement officer. He cancelled that Khatian.
So the first appellate court had relied upon this Khatian also
Khatian also. And
while arriving at the finding.
yes.
So what evidentiary value the Khatian had?
Khatian in the trial court, Khatian was, it was held that Khatian was not, could not be proved by the plaintiff. In the appellate court, it was held that the evidence provision of section presumption was held that since it was a documents which is more than 30 years old, so it was held as proved. Similarly, the rent paying receipt was also held to be proved because those documents were also found to be 30 years old. And it was held that those documents were recovered from the person who should have the possession of those documents. On those grounds only, that documents were held as proved And accordingly,
So what is the law in respect of the document of 30 years old
that is section 93, Lordship.
of the evidence act?
Of evidence. 90 of evidence.
So in fact, the Khatian was not cancelled by the revenue authority.
Khatian was cancelled. Cancelled by the settlement officer. And after that, the names of the defendants number one.
Prayer was for eviction of the plaintiffs, Lordship.
Their prayer was rejected.
That was rejected.
They have not preferred any appeal.
No, Lordship. Title appeal by the plaintiff only. And that first appellate court reversed trial court's finding. Our suit was decreed now. And against that, they have preferred this regular second appeal. So Lordship 167, the issue number 167, my learned friend has just read out from the first appellate court. If it is correct, Lordship, the first appellate court's judgment is correct, then their first substantial question of law goes, Lordship. There is nothing in this first substantial question of law. My learned friend has to satisfy that the first appellate court committed wrong in deciding issue number 167. He just read out, Lordship, there is nothing wrong by the first appellate court. There should be a substantial question of law, then only this court can interfere in the first appellate court judgment. So this first question is whether the reversal of issue number 1, 6, and 7 by the first appellate court with respect to the finding of the learned trial court are proper. Learned trial court's finding was cited by the learned first appellate court, and thereafter it held that that finding is wrong, so I am reversing it. With reasoning, first appellate court reversed that finding, Lordship. So there was no wrong committed by the first appellate court. If there is no wrong committed by the first appellate court in deciding issue number 167, then first substantial question of law goes, Lordship. Then the next substantial question law, whether the findings of the first appellate court that Exhibit 2, which is rent payment received, draws the presumption under section 90 of the Evidence Act is proper on the face of the Exhibit 2, where no signature of Abdul Ghani Sarkar, landlord, appears. He cannot satisfy this court on this substantial question of law also.
So this Abdul Ghani Sarkar already died.
Already died. So court presumed that it is a valid document.
Okay, let us defer the matter for another date. Our suggestion that next Tuesday or Friday, Thursday.
Lordship.
Last week of August.
Lordship is making it part of Lordship.
Yes.
22nd of August.
Then next Tuesday, your Lordship can complete.
Next Tuesday, some other matters are there.
Lordship. Then next Thursday is 15 August, Lordship. Then 22nd August. 22nd August, my learned friend is suggesting. That is a-
22nd?
Yes, but that is a Thursday, Lordship.
Okay, okay.
You should make it.
Your good name, please?
AD Soudhuri.
AD?
Soudhuri.
Soudhuri, learned counsel for the appellant, and Ms. R.S. Soudhuri, learned counsel for the respondent. Heard in part, list the matter on 22nd.
Deeply applies.